All right, we can begin whenever you guys are ready.
Good morning, everyone, and thank you for being here. My name is Joe Rafferty, and I am the Senate Chair of the Labor and Housing Committee. We're here this morning. This is our first public hearing of this session, and I anticipate that it'll run smoothly, but in the world of electronics and a post-storm here in Maine, we may have some difficulties. So we'll do our best to work through this. I know that in terms of the computer and all the fun that comes with it, it's not my strength, but I'm fortunate that we have some folks on board that can help us out if we have needs. The committee is assembled today electronically for the purpose of inviting public comment on legislation. Before we get started, I just want to share some information related to the fact that it is being done electronically. The first, obviously, is patience, but it is being live streamed on the committee's YouTube channel. So that means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People on the Zoom meeting waiting to testify cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel soon after this meeting has concluded. In just a moment, I'm going to have committee members introduce themselves, but before I do, again, just going to ask folks that are on if we can keep our mics muted as best we can. I know I found with my own, I forget sometimes, and I'm reminded later that I'm making noise with my paperwork and stuff, so that would help. Those of you that are testifying, in order for us to recognize you, if you would please be sure that your name appears on your screen the way that you want it to, or help us in terms of recognizing folks. So at this time, I'm going to ask our committee members if they would, starting with House Chair, Representative Sylvester, if you'd introduce ourselves, and we'll go through the committee. Thanks.
Thank you, Mr. Chair. My name is Mike Sylvester. I am the representative from District 39, which is the Eastern Peninsula portion of Portland and the Fighting Islands of Casco Bay. Today, I will serve as the timer. And Senator Rafferty will talk about that in a minute. But at 30 seconds, I'm going to hold my phone up. So if the testifiers are in gallery view, they'll be able to see me do that. And then when your 3 minutes are concluded, I'm going to ask you to please finish your thought and wrap up. Everybody will be on the 3-minute clock, except for Bill's sponsors. And I will try to be as least rude as I humanly can be about it. But until we figure out a good way to have that on screen so everybody can see it, this is the best way we've been able to figure it out. Thank you, Senator.
Thanks very much, Mike. And Senator Guerin.
Thank you, Mr. Chair. I am Senator Stacey Guerin. I represent Southern Penobscot County.
Thank you very much. Senator Merrimont. Dave, I'm not seeing him. Thank you. Representative Bradstreet.
Good morning. I'm Representative Dick Bradstreet from House District 80, and that's comprised of Vassalboro, Somerville, Windsor, and part of Augusta.
Thank you. Representative Cuddy.
Good morning. Thank you, Senator. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville.
Representative Drinkwater.
Thank you, Mr. Chair. Good morning. I'm Representative Gary Drinkwater, District 121, representing the fine towns of Elton and Argyle and Corinth, Hudson, and my hometown of Milford. Thank you.
Thank you. Representative Gear.
Thank you, Mr. Chair. I'm Tracy Gear, representing House District 9, which is Kennebunkport and the coastal parts of Biddeford and Kennebunk.
Thank you. Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent the towns of Turner, Leeds, and Livermore, House District 75.
Thank you. Thank you. Representative Pebworth.
Good morning, everybody. Thank you, Mr. Chair. I'm Sarah Pebworth. I represent House District 133, which is in the Blue Hill Peninsula and includes the boat builders of Brooklyn.
Thank you. Representative Prescott.
Well, hi, I'm Dwayne Prescott, House District 17, which is Waterboro and part of Lyman.
Thank you. Representative Rader.
Hi, I'm Amy Rader. I represent District 125, which is part of the great city of Bangor.
Thank you. And Representative Warren.
Good morning. Thank you, Mr. Chair. My name is Sophia Warren, and I represent my home district of Coastal Scarborough.
Thank you. Just so everyone's aware, our clerk this morning is Alyssa Thompson, and our analysts are Rachel Tremblay, Lucia Nixon, and Steve Langland. For each bill, we're actually, I'm gonna blanking on the bill number. I don't know why, but for each bill being heard today, I will have I will call on the sponsor, or my co-chair will call on the sponsor to speak first, and when they're called upon, you'll be prompted from attendee to a participant. And after presentations by sponsors and co-sponsors, we'll call on members of the public based on how they registered to testify. Many of you registered you were either for the bill, against the bill, or neither for nor against, but wishing to provide some information. When you're called upon, I'll ask you to state your name, your place of residence, and the organization you represent, if any. After you're done speaking, and there are no more questions from the members, I or my co-chair will return you to the attendee and call upon the next person registered to speak. When you're called upon, again, please make sure that your microphone is not on mute. That's one of my tendencies. And it will be greatly appreciated if when you're done offering testimony to the committee on the bills, that you exit the Zoom meeting and you may continue to watch the hearing on the committee's YouTube channel. If you need to exit the meeting before being called upon to testify, please be aware that you may submit written testimony at any time by accessing the legislator's testimony submission page at legislative.maine.gov. And again, just some final reminders, the meeting is being broadcast and recorded on YouTube and can also be heard over the legislature's audio broadcast system. Any testimony you submit is public and may be posted on the legislator's website. As Representative Sylvester mentioned, you'll have 3 minutes to speak, with the exception of the presenters, sponsors, if there aren't any questions from our committee prior to, we're going to open the meeting today. And we are first going to hear on LD 37. It is an act to amend the laws concerning the retired county and municipal law enforcement officers, municipal firefighters, and health insurance program. That is being sponsored by Senator Libby of Androscoggin. Senator Libby.
Alyssa, can we check in with Senator Libby and see if
So when you promote somebody, it just takes a moment for them
Oh,
to
okay.
exit and then rejoin as a panelist.
Perfect. I didn't see him in the list, but
No,
now I
it's all
see him
good.
smiling on my screen. All right, perfect.
Good morning, Senator Rafferty, Representative Sylvester, and members of the committee. My name is Nate Libby. I proudly represent the people of Lewiston in the State Senate, and I'm here to present LD 37. Before I begin my remarks, first, I'm very pleased that I'm stepping in here to be the first person to sponsor a bill in your committee. I expect it will go well. I hope I've brought you a bill that will be an easy one for you all to take up here in your first hearing. Second is I'm used to going to the Capitol for this work, and I always put on a tie when I head to the Capitol, and I didn't do that today, and I forgot, honestly. So I apologize for that. But with that, I will get into my testimony. So the bill that we've brought to you today for members of the committee who are returning from the last session, you may recall that I brought this bill to you last year before the pandemic began. This bill was intended to make technical corrections to a larger bill that we enacted in 2019. So in early 2020, I came back to the committee with a bill on the same subject, making some technical corrections to that original bill that we passed in 2019. The bill that I brought to you in early 2020, we worked it together as a committee, and proud to say we were able to work together towards a unanimous ought to pass report that ultimately wasn't acted upon due to the legislature ending its business early. So the previous bill made numerous amendments to the retired county and municipal law enforcement officers and municipal firefighters health insurance program with an eye towards ensuring that earned benefits are accrued and dispersed fairly. The goal of this bill is the same. Current law requires that a person hired on or after October 1st, 2019 to enroll in the retired health insurance program to do so no later than 5 years after they're hired, conditional on the enrollment and eligibility requirements of the applicable health plan. This bill removes that condition. The bill also changes the percentage of gross wages for contributions, removes the requirement of 60 months of contributions by enrollees, and changes the state's payment of certain premium subsidies on payment from the plan to payment directly to the enrollees. And then finally, this bill makes these changes retroactive to September 19th of 2019. So again, this might be a refresher for members of the committee who are returning. For new members, you certainly may have questions about what we're trying to accomplish here. I'm happy to try to answer general questions, but if you have technical questions about the nuts and bolts of this health insurance program that exists for our local first responders, there will be representatives who will be speaking after me, particularly representatives from the Maine Association of Firefighters, who I view as my go-to technical experts on this program. So if you have technical questions, I'd say rather than waste anyone's time, I might suggest holding them for the folks that will follow me. But with that said, the bill that's presented today is the same as the unanimous report that the committee reported out last year, and that includes the fiscal note as well. The fiscal note has been prepared, again, because it's the same bill from early last year. The very minor adjustments from a fiscal perspective can be absorbed within existing resources. So this bill has no fiscal impact. Again, minor technical changes to the program. Appreciate your attention this morning and happy to try to answer any questions you may have.
Thank you very much, Senator. Are there any questions? Representative Sylvester.
Thank you, Mr. Chair. Thank you, Senator. I appreciate you bringing this bill back. As I remember this bill, the key to both the bill we passed in 19 as well as this technical correction bill is really to help to keep our firefighters and police on the job, and being able to make it to retirement, because some of the younger firefighters and policemen, when they came in, didn't understand maybe how important retirement was, missed the window, and this is kind of gave them an opportunity to get back in the program in order to retain these important first responders. Am I correct in that summary?
Yeah, we're primarily focused on the health insurance program, but the sentiment is absolutely correct. A lot of folks who are entering this form of public service as younger people, when they're doing that initial hire paperwork, they're making decisions on numerous different HR benefits, and sometimes a decision that's made, at age 20, 23, with respect to health insurance, you may want to reconsider that as you begin your family and that sort of thing. And so the crux of this at the outset a couple of years ago was to make sure that folks had the opportunity to enroll, reap the benefits, pay into the system, and that was really where it came from.
Thank you, Senator. Of course, I meant health insurance. I have retirement on the brain. I was just reading a retirement bill, and when I'm at home, Senator, I wear my tie around my ankles. So
I will wear a tie for the work session. I pledge that.
Thank you. I have a question from Representative Pebworth, please.
You're on mute, Representative.
Thank you so much. I apologize for that. Thank you, Mr. Chair. Thank you, Senator Libby. I was going to ask about the fiscal note, and then Mr. Langland helpfully put the link in the chat, and all the information is there for other committee members who may have such a question as well.
Any other questions? Seeing none, we have some
question. I have a question. Is that okay?
Sorry. Yes, Representative Warren.
So I just wanted to ask you, Senator, I guess, can you say anything more about the process of maybe why these corrections are needed now? Can you talk about just maybe the process that you feel you've taken in maybe say due diligence to make sure that, you've resolved issues and are maybe not missing other things? I'm sure there is a process, but I'm just kind of curious if you could explain the strategy behind that, or maybe it's just these were completely unforeseen, in which case I'm curious about that as well.
Yeah, it's a great question. Thank you, Representative Warren. In 2019, we made some, I would say, significant policy changes to this program. And that was an extensive process working with the Labor and Housing Committee, the representatives from the associations of firefighters and associations of law enforcement officials. And our group also worked with the state treasurer's office, as well as the Maine PERS office, and then I believe perhaps one additional office in the state, to make sure we were getting this right. It is not uncommon when taking on substantive policy changes and moving that legislation through to enactment, that when folks begin to implement those changes, there are honest mistakes discovered or unintended consequences of the drafting of certain language. So I would characterize that 2019 effort as the major policy change that we got together and were able to enact, and that the 2020 bill, which is the same as this 2021 bill, as amended by the committee, is that technical amendment process. And again, I think the folks I've been working with who are involved with implementing these changes, they're the ones that have brought this to my attention, asked for me to sponsor the technical correction piece. And I've been happy to work with them on that. And I think Ronnie Green from the Professional Firefighters Association will be testifying after me. And I believe he'll be able to further give you detail on that background.
Can I ask a follow-up?
See, yeah, there's no one else hand up. Go ahead, Representative Warren.
So thank you so much for that response. This may be a question for Mr. Greener or others, but when you reflect now, if you could wave a magic wand, is there something that you or those associated, or maybe our committee, to learn from, so we don't maybe repeat, if we could learn from the experience? Because of course, unintended consequences, depending on what we're talking about, that could be big, and I'm sure it's inevitable, of course. But yeah, is there anything that you feel you've learned from the experience that those associated would do differently next time?
Thank you for the question. I would say we typically make our best effort to get things right, and we've got several layers of review in drafting the bill, bringing the bill to the committee, working the bill and amending it in committee, then voting it on the floor. Especially when there's a fiscal note, there's an additional review at the appropriations level. But technical errors are not uncommon in our work. We typically have a bill each year that is solely focused on technical corrections to all of state statute. It's also common to have those technical changes worked into budget documents, and then in my experience, I have sponsored a few bills to go back and make some technical changes to bills that we did together, and I don't believe it is anything more than honest mistake or not being able to predict the future to anticipate all of the unintended consequences. So I view this as a very normal function of our process.
Thank you.
Great,
Any other
thank you.
questions of Senator Libby? Thank you very much, sir.
Thank you.
Are there any co-sponsors wishing to testify? Okay. Seeing none, then I do know that we have, at least I believe we have some. We'll hear next from anyone in favor of the bill.
I believe on my list, Paul Gaspar. From the Maine Association of Police.
Yeah, I think it just takes a little bit of transitioning time here. Mr. Gaspar?
Yes, good morning. I'm trying to get my video up and running. Very good. Good morning. Good morning. We are, our heat is not working in our office this morning, so I was jealous of the people with wood stoves talking earlier. Good morning, Senator Rafferty, Representative Sylvester, ladies and gentlemen of the committee. My name is Paul Gaspar. I am from South Portland. I'm also the executive director of the Maine Association of Police. We are one of the original stakeholders of what has been lovingly known by us as LD 1021, which has been in existence since 2006. And I'm here to speak on behalf of our members and board in support of LD 37 as titled above. Firstly, it's very good to see you all. Thank you for coming back. I hope that your families are healthy and well, and appreciate your time today. LD 37 represents the same work that was undertaken as Senator Libby has said, under the last LD of 2049 of the same title, which was unanimously passed out of this committee, and before making it to the floor, like many things, became a casualty of the pandemic emergency. So LD 37 continues the intent of LD 2049 and addresses technical changes to allow for the proper administration of the program. And, as all things, we always strive for perfection and hope that's what we get. These are technical changes that clean up some language from the original law as to the 60-month requirement, but also now creating an open enrollment session. And part of that open enrollment does take into account a person's date of hire as to trying to be good stewards of the fund and to make sure that people coming into the program who had a prior opportunity, much like MPERS, as you may be familiar with, in contributing into the program to account for the time that they were not a member. And then you have a second group who are people who are new hires, who this will be their first opportunity to take advantage of the program. And one of the large technical fixes is that the percentages that addressed the first as well as the second have been transposed. So in being able to transpose those back, it allows us to continue on in the program because currently we're in limbo because we have to follow the existing law, and that is currently affecting people's decisions on either getting into the program or getting back into the program. So as original stakeholder, we fully support this, and thank you for your allowance to let us make some comments. I'm happy to answer any questions.
You were right on time, Mr. Gaspar. And since we didn't do a full day of people introducing themselves who are kind of regular players, if you want to take a minute to just introduce yourself and who the members you represent.
Oh, sure. Good morning to all those coming in. My name is Paul Gaspar. I'm the Executive Director of the Maine Association of Police. We currently represent about 950 municipal police officers and public safety dispatchers throughout the state. And we were, along with the Professional Firefighters of Maine, one of the original stakeholders in seeing passage of LD 1021 into law, which is now Chapter 446.
Thank you. Do we have any questions for Mr. Gaspar? No. Seeing none.
Wait, I do have a question, if
Yeah.
that's okay.
Yes, please, Senator. I'm sorry, Representative Warren.
Thank you so much. I wanted to ask you a similar question. You may have heard me before, but Mr. Gaspar, if there's anything, considering unintended consequences, is there anything you would recommend, or as you reflect, that could be done differently? I've been reading different testimony, and I understand at a certain point there's some confusion around inverted percentages around the open enrollment and the period of time a person would need to pay contributions back to. This may be very simple, but is it possible you'd recommend people, you get someone who would need to read this and do the very thing that we're instructing to do, and so you maybe want to have someone, a police officer that would be considering this, to have that run through, just to make your work easier and those that you represent, to avoid unintended consequences in the future.
Sure.
I hope my kind of inquiry makes sense.
Oh, absolutely. I appreciate the question. I think that anybody we've had the pleasure to work with on the furtherance of this program at the state level have all been extremely helpful. And I think it's just the ghost in the machine that, when there's 2,400 bills and the people are constantly in motion on all of these bills, that again, unintended consequences is essentially, we always have to factor in human error. It's not intentional or malicious. It just happens. And I think we recognize that as part of the process. But we also know that this is a body that in this committee that values that as well, as far as sitting and helping us through in the fixes as well. So we kind of look at it as the holistic approach, always with the end goal to put out the best program for police officers and firefighters. And this is just one more hurdle to overcome. But I know once we're past that, we'll be in good shape. I don't know if there's a silver bullet to prevent it from happening again. But I think the recourse to that is having good people to assist us in writing it.
Thank you very much.
Thank you.
Thanks, Mr. Gaspar. Any other questions? I do believe that waiting in the wings, we have one additional proponent, Mr. Green.
Good morning. Am I here?
Yes, sir, you are.
Okay. Well,
Welcome.
I've probably spent thousands of hours on Zoom meetings over the last year, but this is a brand new one for me. So, good morning, Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. My name is Ronnie Green, and I reside in the town of Plymouth. I am currently a district vice president with the Professional Firefighters of Maine, representing over 1,000 full-time career firefighters, EMTs, paramedics, inspectors, dispatchers, and mechanics across the state of Maine who belong to the International Association of Firefighters. I'm here today to speak in support of LD 37. This bill is actually the same exact language that this committee worked late last session and had a unanimous ought to pass as amended report. Unfortunately, before LD 2049 could get to the floors of the Senate and the House, COVID struck and everyone went home, leaving the bill behind. I would like to thank Representative Sylvester, Senator Guerin, Representative Bradstreet, and all of the committee members for their work in getting this out of committee last year with a unanimous vote of support. The reason for the emergency preamble is because the current law provides for an open enrollment period that ends December 31st of this year, 2021. Rather than waiting for the 90 days after the legislature adjourns this year, we wanted to be able to provide more time to process any open enrollments that will come in. The reference to the 60 months was carryover language from the original law that was passed back in the 122nd legislature that addressed current and soon-to-be retirees back then, ensuring they paid a minimum of 60 months of contributions before receiving a subsidy. That should have had a sunset provision that ended in 2012. It is not necessary language and only causes confusion now because the law clearly states that participants must pay contributions into the program from their date of hire or January 1, 2007, if they were hired prior to that. State Employee Health and Benefits identified a problem with paying subsidies directly to the insurance carrier of a spouse and suggested we remove that section and allow the state to pay the subsidy directly to the retiree as long as they provided proof of coverage. There was a lot of confusion and some inverted percentages around the open enrollment and the period of time a person would need to pay back contributions to get caught up. The intent was to have people pay back to their date of hire or January 1, 2007, whichever is latter. Everyone that is currently in the program started in January 1, 2007, or their date of hire if that was after that. This program, this would make it fair for people to buy back into the program as well as protecting the existing funds in the program. Thank you for your time, and I will be happy to answer any of the questions.
Also, right on the button, Mr. Green. I appreciate that, as always, a professional. If you want to take, as again, someone that we're going to see fairly regularly in this committee, I wonder if you would take a minute and tell us a bit about yourself and your members.
Thank you, Representative. And you've schooled me well. That's why I learned to stay right on the 3-minute clock. So again, I am Ronnie Green. I'm retired career firefighter of the city of Bangor. I retired 28 years of service. I still work with the Professional Firefighters of Maine, representing directly most of the firefighters in the northern part of the state, north of everybody north of Augusta, pretty much. We do have over 1,000 full-time career firefighters, paramedics, dispatchers, inspectors around the state, and I do a lot of the legislative liaison work for that group. That's kind of me in a nutshell, I guess.
Thank you, sir, and thank you for your service. We do have some questions. It appears, Senator Guerin, please.
Thank you, Mr. Chair. And I just wanted to welcome Mr. Green. He is one of my constituents. I miss seeing you in the hall, Ronnie, but it's good you're here to testify, and I'll be supporting this bill again this year. So thanks for bringing it back.
Good. Thank you, Senator. I appreciate that. I also wanted to add, too, that real quick, that the Maine Fire Protection Services Commission met the other day, which is a group that makes up all the people in the fire service in the state of Maine, and they voted unanimously to support this legislation. And you should have in your packets, or will have, a letter of support from those people as well.
Thank you, sir. Any other questions, folks?
I do have a question.
Yes, Representative Warren.
Thank you so much. So thank you so much for your testimony and your written testimony, Mr. Green. I really appreciated it, and it had me curious and caused me to just to understand. I appreciate your patience with me. I feel like if there's a firefighter who is considering this, maybe you would read through and you would maybe begin to get that sense of confusion. For example, with the reference to 60 months being unnecessary carryover language, and you mentioned there was a lot of confusion, and so that's totally understandable, and I understand if this is kind of how you do this work, but I'm wondering if there would be something you'd consider checking or you'd consider for us and future legislators to not come to that kind of confusion in that way.
Representative, that's a great question. Thank you for asking, and I was prepared for you because I see you'd asked a couple before. But as I prepared for this morning, I looked at my testimony from last year, and one of the bullets I picked up in it, and forgive me, I gave my glasses on, I'm half blind here, but one of the bullets in my testimony from last year was, as I was preparing this testimony and reviewing the bill as written before you, I realized that some of the corrections and edits that were worked on between myself, State Employee Health and Benefits, and the reviser's office were not included in the final draft. And I guess what I can simply say to that is, I think we've all heard the term, there's too many cooks in the kitchen will ruin the stew, or something like that. And I don't want to say in any way or point any fingers that anybody ruined any stew, but I'll take this moment to thank Senator Libby and his staff who helped us work through this back in the 129th with the original bill LD 1674 and then the fix LD 2049. But even in this revision LD 249 that came out last year, several versions went back and forth between several of us that worked on the language of that bill. And actually, simply what happened is that final version that the reviser's office sent out was like one version old or something like that, I guess would be the thing to say. So I think it's simple human error sometimes how these things happen. And I think Senator Libby alluded to that sometimes it's just consequences, of changes, like the 60-month thing was something that, like we said, should have come out back in the 122nd. It didn't. It should have come out in LD 1674 in 2019. And nobody really caught it until we got reading the law as it was written and said, hey, that shouldn't be here anymore. There's no need for it. So I don't think there's any finger pointing. I think it's just, as Senator Libby said, you know, sometimes as we make changes to things, we pick up things that going forward that will make a difference.
Thank you very much. All right. Any other questions for Mr. Green? Here's we're all set. And Alyssa, I don't see. Thank you, sir. And good luck with this. Alyssa, I don't see anyone else for. Is there anyone to speak against? And
you were on mute, Alyssa.
I forgot I have a second button on my thing. Those are the only two that had registered to testify.
Okay. Well, let's, having received testimony from everyone present today, and it appears there's no one else in the waiting room, I'll close the hearing on LD 37. And thank you folks for being here today with us. Senator Libby, have a good day.
Very much. Have a great morning.
Thank you. I'll try to get my paperwork in order here. So we got 37, 37, 37, 37. Okay. I think we're 61 is coming up. Okay. The next bill in terms of hearing, let's see if I'm all right. I'm on. All right, okay. I'm not muted. Next bill up is LD 61, an act to include grandparents under Maine's family medical leave laws. And this is being presented by Representative Stearns of Guilford and co-sponsored by Senator Davis, Representatives Corey of Wyndham, Fay of Raymond, Landry of Farmington, Toole of East Machias, and Senator Guerin of Penobscot. Thank you. So, Alyssa.
We have Representative Stearns.
Excellent. Representative Stearns, welcome and thank you very much for being with us this morning.
Good morning. I was hoping to play some live Hollywood Squares this morning on my computer.
Well, my squares often get mixed up, but we're happy to have you with us and we'll try to keep you in order.
Well, I appreciate that, and I appreciate the opportunity to present this bill. It means a lot to me because it's one of those that came to me from a constituent who is a working grandparent, has worked all her life, and ran into a situation where one of her youngsters was being treated due to opioid epidemic, and she was taking full care of the grandchildren. So I'll proceed with my testimony. But again, those type of seminal bills are the ones that really tug at my heart. Senator Rafferty, Representative Sylvester, and distinguished members of the Joint Committee on Labor and Housing. I'm Paul Stearns, and I represent House District 119 of Piscataquis County, and I'm seeking your support today on behalf of the working grandparents of Maine. During my years of working in the public school system, I became acutely aware of the number of times where grandparents were providing critical support to grandchildren. Very rarely in situations that warranted the parent relinquishing custody. Caring for a grandchild in the absence of a parent is a natural occurrence. For instance, let's say that the parent of a child is in treatment for substance abuse. The grandparent is, in effect, providing for their own child by assuming the care of the grandchild. No matter what the issue, when our working grandparents are called to provide care for their sons, daughters, grandsons, and granddaughters, it makes sense to remove the worry of losing employment from their plate. All of the rules, qualifications, and limits of FMLA that exist for children would exist for grandchildren. With an ongoing pandemic, as well as our opioid epidemic, I feel that this legislation deserves emergency status. I'll do my best to answer any questions that you may have, and thank you for considering this legislation. And if I could add one note, I want this to be only for working grandparents that have direct and primary supervision responsibilities, but fall just short of having legal guardianship. It's not my intent to make this a double dipping type where a parent may run out of FMLA days and transfer it over to the grandparent. So I'll leave it at that. And again, I'll do the best I can to answer any questions that you may have.
Thank you, Representative Stearns, and especially for that clarification. I'm sure that that will be very helpful for us.
I apologize for not having that in the language, but it's that is a critical component to this.
Thank you. I see some committee members. First hand up, Representative Sylvester, followed by Representative Prescott, please.
I'm on live.
Thank you, Representative Stearns. So my question was, so you do, and I think you might have just answered it there at the end, but so you would like a definition of grandparent as part of the statute, or would you want that in rulemaking? Or the direction of what you're defining grandparents as?
I believe it would be in rulemaking, but I'm not 100% sure there.
I think you're right. We'll ask some of the folks from DOL who
there are folks that know much more about those administrivia details than I.
Exactly. All right. Thank you, Representative.
Thank you, Representative Sylvester. Representative Prescott, please, with a question.
Well, thank you. Is this bill directed at where parents are actively in, say, rehab or seeking help, or are they just still out running around and the parents are accepting responsibility?
Thank you for the question. When I first put it in, it was before any COVID, and it was really due to the opioid epidemic that parents were reluctant to go seek treatment because they had no childcare. And oftentimes the children would end up with the grandparent. But as I looked at it more and more, as long as the grandparent was the primary and direct provider of supervision for the grandchild, no matter what the situation, I would allow FMLA, the state rules, to apply to the grandparent. I know that when I was superintendent of schools, oftentimes we dealt with grandparents who raised children all the way up through school. Their parent was absent for whatever reason. Yet full guardianship was never transferred in the courts for whatever reason. I don't know. I hope I answered your question.
Thank you. Representative Warren.
I think that Representative Cuddy may have been in front of me.
Oh, thank you very much.
I
Sorry
hope that's
about
okay.
that. Representative Cuddy.
Thank you very much, Senator. Thank you very much, Representative Warren. Yeah, Representative Stearns. So first off, very nice to see you again.
Nice to see you, sir.
I really appreciate this bill. I just wanted to chime in to say that I'm very supportive of this effort. I have a lot of grandparents in my district who have responsibility for raising the kids, and they are looking for any help they can get in trying to raise these kids in much the same way oftentimes that the children's parents would be doing. I did want to ask you about the clarification, and I wanted to use my particular situation to see how it works. Right now, my mother, who is the grandparent, obviously, of my two kids, spends a lot of time taking care of them, but she doesn't have direct responsibility. Now, in her particular situation, she's not working anymore. She's retired. But if she were, she would, under the last part that you brought up, the clarification part you brought up, she would not qualify to use FMLA because she does not have primary custody of the children. Is that right?
That's the tightrope. That's the piece for us to get through. And the only way I can do it is to run various scenarios. For instance, let's say your mom was still working, and you decided in a lapse of judgment that you were going to be a state legislator and spend an enormous amount of time in Augusta, Maine. And so Grammy decided to take FMLA to look after the children. That would not qualify. And it goes back to the regular FMLA rules. However, if you were, let's say that your employer said you needed to stay on a ship offshore from Bar Harbor for 3 months due to COVID restrictions, that's a medical event, and Grammy would then be the primary, even though it's fairly temporary, only 3 months, she would be the primary provider and would then qualify. Did that example help?
It does, and I mistakenly used the term custody, and I don't want to introduce custody into this. As soon as I said it, I wish I hadn't, but the primary care provider statement you used, I think, was a lot better. Thank you very much, Representative Stearns. I appreciate it.
Thank you.
Thank you. And Representative Warren, and then Representative Rader.
Thank you very much, Mr. Chair. And thank you very much for your testimony. I'm wondering, I feel like many different people could have a number of explanations for this. And I'm just curious how you consider the issue in testifying today, if you have a view. There's some written testimony from the Maine Chamber of Commerce, in part kind of making an argument, this would be nice, but we can't afford it. And I'm wondering, why do you feel it's, or how would you respond to that?
Well, as a former school superintendent, when you really had to monitor those labor issues and sometimes really take a tough stance, my initial reaction, I can understand, I haven't read the chamber's testimony, but I understand the reluctance of, boy, one more burden on employers, if you will. I would swing that as you think through it more off, a little further. I would say that the opposite would be true. We need a healthy workforce, and we need job stability for folks. We need healthy families and healthy workers. If FMLA is a good idea, and I think it is, to protect the employment of a parent who, due to unforeseen circumstances, has to be away from the job. In the same token, why would it not be for the grandparent that's in that exact same role? And I would also add, oftentimes, I'm sure the folks, many of the folks on this committee, I'm preaching to the choir, but oftentimes folks confuse FMLA with paid leave. And that's not the case. This merely starts a clock for time that a person can use without the repercussions of losing their employment or losing that position. Local labor conditions and other state or federal statutes would cover any type of compensation. I hope I answered your question.
Yes, thank you very much.
Thank you. Representative Rader, and then Representative Gear.
Thank you, Mr. Chair. I have a question regarding the documentation of that guardianship when the grandparent is the primary caregiver. And your example that you gave with someone being away for 3 months and the grandparent coming in as a temporary caregiver. what kind of documentation do you think we'll need, or are we looking for in those cases? Because in the case of kinship or actual legal guardianship, we have very clear determinations of who's the guardian. In those temporary situations, I was wondering if you had any kind of recommendation or any kind of thought as to how we would document that. Thank you.
I would use the exact same rules that a human resources department would use now for a parent. So just the fact that a person does have custody or responsibility for the child, that child might live in another state somewhere. and it would be unlikely that they would be granted FMLA for that. So I would use the exact same rules as they sit and go down through their paperwork and the criteria of, okay, does this person qualify? You would just put the word grandparent in with parent, where parent. Yeah.
Thank you. Representative Gear?
Thank you, Mr. Chair. Actually, Representative Stearns, that Representative Rader asked the question that I had, but your response did bring to mind another question, which is, in that situation that we're kind of using as the model, where we have someone who's away and therefore needs to sort of transfer that responsibility for that child very clearly. Someone is not there, so they're going to have to notify the school and say, okay, I'm going to be away for 3 months. My mother is going to be taking care of so and so. But the challenge in that situation, in a situation that's less clear, so say there was a situation where someone was absent, a parent was absent for another reason, if it's a medical reason or there's just some sort of absence that needs to be covered, it seems much less formal than that and much less clear cut. So I would just ask if you've thought through some of those situations that are a little more gray and not so easy to deal with as, hey, the parent just isn't here, so we need to have the grandparent stepping in temporarily.
I think they would always have to be medical in nature with FMLA. And again, as I started to think through each one, I said, why bother to do that? That's been done. The history of the program, that's been done. So again, I would go right back to applying those same rules that have been decided as FMLA has evolved, to use the same criteria that the person would use, that checklist, if you will, for that they use for children, that they would have for grandchildren. I didn't say that very well.
Thank you.
Thank you both. Senator Guerin, please.
Thank you, Mr. Chair, and thank you for bringing this bill. I'm one of the co-sponsors, so obviously I love the concept. Having served 3 terms on judiciary, I know we often heard from grandparents who were in the situation of raising their grandchildren, but it was kind of off the books. The parents still had custody. And so we were always looking for remedies for those grandparents who needed help pretty desperately. I'm wondering, are there mechanisms in this bill, and maybe it would be a question for Steve Langland, our analyst, but are there stipulations in here that would prevent the kind of double dipping, that the parent took it and then the grandparent took it? That they both had it. Is there an oversight mechanism there?
Again, I think I alluded to that in my comment after, just toward the end of my testimony. I do think it would take an analyst's eye to do that, and I concur with you wholeheartedly, Senator. That and I think I mentioned, I do not want that double dipping opportunity in any way. That all those criteria would have to be met, and I use the word primary direct supervision. But
and do you think that somehow rules out a grandmother that babysits every day?
No, I think that would include.
But you could get other child care.
No, yeah, let's run that by the analyst again. Thinking, I said no initially, but now I'm going to say yes. That's not primary and direct care. That youngster's going home in the evening, having their meals with their family. That's more of a convenience, if you will, that they have that support system. But they could get other childcare, as you just mentioned. So I don't think that would qualify for FMLA.
Thank you.
Thank you. That was an excellent question, and I'm not. It's not lost on me the fact that this is a very, very tenuous. We don't want to open that can of worms, but we want to provide support for those employees.
Thank you. Thank you both. I see one more hand up. Representative Gear, do you have an additional question?
I left my hand up from before. Sorry.
Okay. And I see no additional questions from Representative Stearns. So thank you very much, sir. Are there any co-sponsors wishing to testify? Any other? Seeing none. Are there any proponents willing to speak for this in the waiting room at all?
We have a few that registered. Would you like me to just go through the list and promote them?
Sure.
Okay.
I believe Isaac Gingras was next from DOL.
I just promoted him.
Perfect.
Okay, so I have Isaac. Is it then Jeffrey? No, we've got a few. Isaac, can you hear us?
Yes, I can. Can you hear me?
Yes, we can. You're
Awesome.
up, sir. Good morning. Thank you for being here.
Yeah, thank you for having me. Good morning to the committee. Senator Rafferty, Representative Sylvester, and members of the Joint Standing Committee on Labor and Housing. My name is Isaac Gingras, and I am the legislative liaison for the Maine Department of Labor. On behalf of the department, I am offering this testimony in support of LD 61. Currently, under the Maine Family Medical Leave Statute, leave may be provided for a worker caring for a child, domestic partner's child, parent, domestic partner, sibling, or spouse with a serious health condition. This bill would simply add grandchildren, including those of a domestic partner, to the list of persons for the care of whom an employee may request family medical leave from their employer and be entitled to unpaid job protected leave in accordance with the law. In the light of the many potential stresses on the health of Maine workers and their families, including both the current pandemic and the devastation caused by the opioid crisis, the department recognizes the merits of providing family medical leave protections to grandparents similar to those provided to other family members. For this reason, we support this proposed expansion of coverage. We would, however, recommend that the definition of covered employees be clarified. It is possible to interpret the current statute to include grandchildren and thus grandparents and its protections, specifically the term child in section 843, subsection 4, paragraph D, could refer to any person under the age of majority, as it excludes any reference to the child's relationship to the employee. Even so, the proposed language added to the definitions would serve to clarify that further, and that is the intent of the legislature proposing this bill. Even clearer would be to add the words employees before child in the current section and grandchild in the proposed amendment, assuming that this is the intent. In addition, it would be helpful to provide a further definition of grandchild and in fact a child that would clarify whether the intent is to include biological, adopted, or other possible legal statuses in the covered parental and grandparental relationships. The department would also suggest clarifying the scope of the legislation if possible. There is a distinction between grandparents who are primary caregivers and those who are not in a primary caregiving role for their grandchild. And it may be beneficial to clarify this in statutory language if the committee wishes to do so. In summary, the department appreciates the overall goal of this bill, and we appreciate Representative Stearns and the co-sponsors for bringing this bill forward. Staff from the department will be available for the work session to assist with the technical aspects of the bill if necessary. And I thank you for your time and consideration of my testimony, and I'm available now to answer questions or at the work session. Thank you.
You actually finished early, so we commend you for that. You had an opportunity to say hello the other day to the committee, but I wondered if you wanted to take a moment to explain your role to the committee or say anything about yourself.
Yeah, absolutely. So my name is Isaac Chingris, and I am the department's legislative liaison. So you'll see me in front of the committee a fair amount and representing the department on legislative issues. I'm also typically reaching out ahead of bill hearings just on bills that are being scheduled or have been printed, just so we can get a better understanding of intent of legislation and what a bill is trying to do. And I'm also just the liaison. So if you have any constituent issues, please feel free to reach out to me directly or just questions on the department in general. I'm that resource for you.
Thank you, Isaac. We do have a number of questions for you. I believe the first hand up was Senator Guerin, followed by Representative Sylvester. Excuse me. Senator Guerin, please.
Thank you, Mr. Chair. And thanks for clarifying some things on there, Isaac. It appears to me from your testimony that you think as written, this would just add grandparent to the list. So I'm just making sure that's what I heard from you, that we would need to add different language to make it be the primary caregiver was the grandparent and not just adding grandparents to a list of people who can get the leave. Is that correct?
Thank you for the question, Senator. I think it would be helpful to look closer at the language because as it is written now, it looks like it might be broader in scope than intended. So we could look at that with department staff just to make sure.
Okay, thank you. I'd appreciate you working with our analyst on getting that narrowed down for us. Thank you.
Thanks very much. I have Representatives Drinkwater, followed by Bradstreet and Sylvester.
So I guess Representative Drinkwater, it's my turn to ask a question.
Yes, sir.
All right, thank you, Mr. Chair, and thank you for explaining some things. My question has to do with, you mentioned unpaid leave allowed. From my understanding of the law, there's a time limit on unpaid leave. And as we all know, you can't hold everybody accountable because every situation is different to how long they're going to take off. So under the law now, is there a time limit on unpaid leave absence?
Yes, in the state statute, it is up to 10 weeks. And under the federal statute, it is up to 12 weeks. So there are two separate programs that run concurrently though. So under the state statute, it's up to 10 weeks of unpaid leave, which is where this clarification would be.
Thank you.
Thanks, Isaac. Representative Bradstreet, followed by Representative Sylvester.
Yeah, thank you, Mr. Chair, and thank you, Isaac, for being here. Really not a question, it's just something to point out, and I appreciate this, what you've told us. From the 1 year I served on a Judiciary Committee, I know that definitions are very important. And I know that they're completely, oftentimes they're reviewing the definitions as well. So what we think of as a grandparent today may not be a grandparent tomorrow, believe it or not. We also talked earlier about the unintended consequences, and I think this is something we have to be careful of right here. The point Representative Warren made before in the previous bill was very appropriate, I think. Thank you. That's all.
Thank you, sir. Representative Sylvester, please.
Thank you very much, Mr. Chair. So, Mr. Gungus, do you think we had a little discussion about this earlier? You may have heard about it. Do you feel like we want to put that definition into the statute itself, or do we want to do that in rulemaking? Because as you know, as Representative Stern said, you know, it's going to be interpreted by you know, folks in HR who make these decisions every day about whether or not somebody's the primary caregiver. And so I guess I don't necessarily need an answer from you definitively right now, but I think for the work session, that's an issue we would definitely want to ponder about whether we want to, you know, secure that in statute, or as Representative Bradstreet said, you know, do we want to have something that gives the ability to change that without having to come back with another LD if situations change? So thank you.
Thank you, Representative. And I would just offer as well, maybe during a work session, Director Rowland or Scott Cotnor, who's the director of the Wage and Hour Division, could provide an overview on family medical leave and what the current statutory requirements are for the committee, if that would be helpful.
That would be very helpful. We would appreciate that. Thank you.
All right, thank you.
Any other questions for Isaac? Isaac, thank you very much for being here today, and thanks for your testimony. We appreciate it.
Thank you so much for having me.
Absolutely. I think, Alyssa, I see, is it Neil Young? Is that up next? I lost you.
Jeffrey Neil Young. I just promoted him.
Oh, I'm sorry. Thank
Oh,
you.
no, all good.
I was excited for a moment that Neil Young might be here.
He is. Jeffrey, can you hear us?
Jeff, you're on mute, if you can hear us.
Okay.
Good morning.
Okay, Mike?
Yes, we can hear you now. Thank you, Jeff.
Okay, thank you. Good morning, Senator Rafferty, Representative Sylvester, Representative Stearns, and members of the committee. My name is Jeffrey Neil Young. I'm here to testify on behalf of the Maine Employment Lawyers Association. We support the enactment of LD 61. The Federal Family and Medical Leave Act extends only to employers with 50 or more employees and does not include grandparents. The Maine Family Medical Leave Requirements Act is broader in scope than the federal law. It applies to employers with 15, not just 50 employees, but it also does not currently extend to grandparents. Leave under the state law is limited to 10 weeks every 2 years. I believe Mr. Gingras may have suggested it was every year, but it's actually every 2 years. And under the federal law, it is 12 weeks every year. It's unpaid under both state and federal law. Under Maine law, to be eligible, an employee has to have worked for the employer for 12 consecutive months. There are apparently 11 states, including Maine, which have enacted their own sort of mini family medical leave acts. And 8 of those 11 states currently include grandparents in their definition of family leave, including California, Hawaii, New Jersey, Oregon, Washington, Wisconsin, the District of Columbia. Connecticut is going to do so effective January 1 next year. Maine, Colorado, and Rhode Island are the only ones currently with state laws that don't include grandparents. But unlike Maine, Colorado, and Rhode Island, as well as the other states that I mentioned, plus New Jersey, Massachusetts, and Oregon, actually provide coverage for grandparents under their state family and medical leave insurance programs. And I've attached a link to a chart. So Maine is really the only state with its own statute that doesn't include grandparents. I just wanted to speak to the comments that Representative Stern said, because Mila believes actually that the law as proposed doesn't go far enough. And we think that, you know, children need to be taken care of, regardless of whether first it's a parent and then it's a grandparent, which I understand to be the double dipping scenario. I also note under section 843 right now that a leave can only be taken if your child is sick. So I'm not sure that it would extend to the situation where somebody has to remain out at sea for 3 months because of COVID. But Mila would like to see the bill actually extended even further that would permit grandparents to take, and parents for that matter,
Mr. Young,
time off.
your time is up. So if you could conclude your thoughts and then
Sure.
we'll have questions
Thank
for
you.
you. Thank you.
To take time off just to provide care for grandchildren, whether or not the parent or grandparent or grandchild is sick. Thank you.
Thank you, Mr. Young. And do you want to take a minute as somebody who we see fairly often to talk a little bit about yourself or, you know, whom you represent?
Sure. And I'm sorry I did not have my video on, but I'm Jeffrey Neal Young. I'm an attorney with Solidarity Law. I am an executive member of the National Employment Lawyers Association and vice president of the Maine Employment Lawyers Association. NELA is the largest organization of civil rights attorneys in the country. We have about 4,000 national and affiliate member attorneys. NELA is the largest organization of civil rights lawyers here in Maine. We have about 75 member attorneys in Maine. Thank you.
Thank you very much, Mr. Young. Any questions, folks, for Mr. Young? It doesn't appear I see any, sir, so you did a good job of covering everything.
Thank you.
Thanks for being with us today, and good luck with this moving forward.
Thank you, and it's nice to see all the new members of the committee as well as some old friends as well.
Thank you. Lissa, we have next person up, I think, is John Kaczynski.
I'm not seeing John in our attendees.
Okay. All right. And what do we have? I don't see any other speakers in the list for the bill. Am I correct?
Yeah. I believe we have 1 against and 2 neither for nor against.
All right, let's, if we could then, let's hear from those folks that are neither for or against.
Okay, first we have Kate Dufour, who I'm promoting now.
Thank you. Good morning, Ms. Dufour.
Good morning, Senator Rafferty. Representative Sylvester, you need not hit the start on your time clock. I will be done very quickly. And members of the Labor Committee, my name is Kate Dufour. I'm here on behalf of the Maine Municipal Association. Provide testimony neither for nor against on behalf of our Legislative Policy Committee. And I just want to make 2 points. We support the addition of grandparents to the list of employees who are eligible for leave. We understand that many of our employees are taking care of their children's children, and we believe that employees who have their minds on their work rather than on a sick grandchild are better employees. So the leave does provide some assistance, and we support it. We do, however, have some concerns with the term grandparent, and we believe in order for this program to be successful, for both employers and employees to buy into it and support it, that we need to narrowly define who a grandparent is. And we do concur with Representative Stearns indicating that maybe we focus on a primary caregiver, somebody who is responsible 24 hours a day, 7 days a week for that, that child, whether or not it's for an interim period or for the long term. We think the definition would make the law much stronger. So I thank you for your time and consideration and be happy to answer any questions you have.
Thank you, Kate. Did you want to take a minute and talk a little bit about, as somebody again that we see fairly regularly, you know, who you represent and who you are?
Sure. So I represent the Maine Municipal Association, and one of your colleagues on the committee had an aunt that worked with us for many, many years. She was in our legal services department, probably one of the smartest attorneys we've had. But so we're a member service organization. We provide services to municipal officials across the state. I work in the advocacy department. And the way the association establishes its positions on policy or bills is not because I like something or I don't agree with something, but we have a 70-member legislative policy committee. It's basically 2 municipal officials. They're elected by their peers, and I mean the boards and councils in each community. And they meet once a month when the legislature is in session, and staff puts in front of them every bill of municipal interest, and they direct our positions on this bill. So today, the policy committee wanted us to let you know that they support the inclusion, but they had some questions with respect to how to define grandparents. So that's us in a nutshell.
Thank you very much. Any questions? I'm not seeing any. Ms. Gord, thank you very much.
Thank you. Have a good one.
Yes, have a good day. Alyssa, do you see anyone in the rings? I think.
Yep. Next we have Peter Gore.
Okay.
Neither for nor against.
Thank you very much.
There we are. Can you see me now?
We can, Peter. Good morning.
Good morning. Good morning, Senator Rafferty, Representative Sylvester, members of the Joint Standing Committee on Labor and Housing. My name is Peter Gore. I am the Executive Vice President of the Maine State Chamber of Commerce, and I'm here to provide you with some information as you consider this bill that we think is important. There are things that the FMLA law is and isn't. It is designed to provide, to involve direct family members and providing them unpaid leave for a serious medical condition, birth, adoption, death, or organ donation. You've already had it spelled out, the employees and the requirements. I think it's important to note Mr. Young's testimony that in Maine, we have 2 FMLA standards. We have a federal and we have a state. The state threshold is 15 or more employees, and that's important as you consider this, at least we think it is, because almost universally Maine's FMLA in general is very burdensome for employers when it comes to tracking and monitoring who's eligible and how much time is being taken. If you're 50 or more employees, you are going to have an HR department. But if you're 15 or more employees, the chances are you're a small business and you're not. So it's difficult to keep track and monitor this. When you don't, you're exposed to potential legal conditions and problems. The issue of adding different family groups to FMLA has been discussed by this committee in the past and has included grandparents. And the legislature has said no. And part of the reason for that is if you allow one cohort to be added, and the last was domestic partners and their children, where do you draw that line? And because you will have other groups who have equally compelling stories will come to this committee and will make their case, and they'll be good cases. So I want to leave you with one more thing before I run out of time. I was very interested in Representative Stearns' discussion this morning and the addition of sharper or more defined language for perhaps direct responsibility. But keep in mind that if you make that change, it's employers and small business guys in particular, and women who don't have HR departments, they'll be left to define what constitutes direct responsibility. And if they get it wrong, it leaves them open to legal challenges. And even if they win those legal challenges, they've still incurred the cost of defending them. So this is a complicated issue. It's emotionally compelling, but for the small business community, it does represent a new burden for them. And with that, I'll be happy to answer any questions you have.
Thank you. Any questions?
Before we go to questions, Mr. Chair, I just wanted to give Mr. Gore, as somebody we'll see more than fairly regularly,
More than you want
a
to.
minute to kind of talk about himself and whom he represents and his constituency.
Thank you, Representative Sylvester. And it's nice to see former committee members back on the committee and to meet new people. As I indicated, my name is Peter Gore. I'm a resident of Brunswick. I've been with the Maine State Chamber of Commerce. I'm starting my 27th year with them, and all 27 years I've appeared before some iteration of the Labor Committee. So I'm familiar with many of the issues that you will discuss over time, and would open myself to be a resource for you if I can be helpful. We are the state's largest statewide business association. We represent the very largest and very smallest businesses in Maine. We have a network of over 5,000 members that includes our One Voice affiliation with local chambers across the state, but we are not the mothership, just so you know. The local chambers operate independently and make their own decisions. I mean, I think that's in a nutshell who I am and what I do. And I offer myself up to provide you with any helpful information that I can on a going forward basis.
Thank you, Mr. Gore. I do see a question up. Senator Guerin, please.
Thank you, Mr. Chair, and welcome, Mr. Gore. Always a pleasure to have you before our committee. I think you've brought up some good points that I hadn't thought of this morning. I think I probably would have as I pondered the bill, but in current law, if a grandparent has custody, then they would be eligible for this, correct?
If a grandparent had custody, sole custody, and was acting as a parent,
yes.
You know, I think you need to ask your analyst that question. I'm not sure my instinct would be yes, but I couldn't tell you that.
Okay, so the analyst can look at that. That being the case, if we said grandparents and defined grandparents, then it would be on the employer to figure out if they were indeed the primary caregiver, giving them legal status for custody.
Well, it would be up the employer would, the employee, the grandparent would invoke their right under the act to take the leave. And then they would say, you know, I have legal custody of, you know, these grandchildren. But there's no, unlike in other areas of the law where the employer is entitled to ask for some kind of certification for that, there's nothing in there. There's nothing so far in the proposal which would indicate that that would be included in this. And so it really is ultimately left to the employer to divine, you know, okay, is this person entitled to this act? Yes, they've worked for me for the requisite amount of time and the requisite amount of hours on a full-time basis. But it's important to note that a lot of the discussion here this morning, and it's a policy discussion that you folks can have on a going forward basis, is a different view of FMLA than it's currently used. People want to use it for caretaking purposes. It's designed for serious medical conditions as it's currently written, and as FMLA is currently, as the statute currently requires that you at both the federal and the state level. So you've had a mixture of discussions here this morning that I think you'll probably want to parse out as a committee, because if you decide you want to go with a direction, well, we need grandparents for caretakers, for childcare, for example, that is not a use that FMLA has been used for unless it involves a serious medical condition.
Thank you for those clarifications.
Thank you. Any Representative Sylvester, please.
Thank you, Mr. Chair. Mr. Gore, welcome back to the committee. Just wanted to, as you know, when we look at changing these sorts of rules and, that are going to affect employers, I'm often very interested in the same question that you are in terms of how we give proper guidelines and rules, particularly to smaller employers. And so I'm wondering if you have thoughts. One of the things that we do is we sort of have the DOL do those on their own. And I'm wondering if you have thoughts in terms of how organizations such as yourselves could better partner with the Department of Labor in terms of creating resources that are clearer and that, perhaps have scenarios and or, make it clear how you would reach out to the DOL to ask such a question. I have an employee X who is telling me A, what do you think in terms of the law? And so I was curious of your opinion on that.
That's a great question, Representative. And, as an organization, we've learned a lot from this pandemic. And part of that is the ability to reach out in the virtual way to our members and provide them with information through a webinar format or electronically. We did work very closely with the Department of Labor around unemployment insurance when the pandemic first broke. And, we had, tremendous stress on the unemployment insurance system, as you are all aware, as a committee of jurisdiction. And we worked very closely with the Department of Labor on providing access to our members and other businesses and local chambers and pushing information out that everybody needed to have. I mean, we could, and we would certainly do that around this issue. I will say that I know there's been discussion this morning, statute versus rule. I'm not aware of a lot in rule around FMLA. I think it's in statute, but I could be proven wrong on that. And again, your analysts can provide you with that information. But I think basically what you see in Title 26 is what employers have to go on. And I don't think there's a lot of rules to fill in the cracks for them. So for a small, in particular, 15 or more employees, 15 employees is a very small business. And they do not have HR professionals. They just don't. The HR professional is the business owner. And he or she is going to have to figure out not only whether when you make this change, and again, there's enough challenges right now with FMLA as it's written, but making this change and trying to decide, is this person to have direct care, indirect care, it's a grandparent, who's grandparent, is it a step grandparent, et cetera, et cetera, et cetera. Are all those going to be counted into this change? And if you are, it needs to be very clearly spelled out to the business community so they have the best opportunity to take care of it. There's one more thing that I didn't talk about, and that is both the federal and the state law allows incremental or intermittent use of the leave. So for example, the feds say you can take up to an hour or whatever division that the employer allows the use of other types of leave. Maine is more amorphous, and it basically indicates that you can take less than an hour of intermittent time. So you could take 30 minutes, you could take 15 minutes. The employer is required to track that information and keep track of when the employee is taking the leave and how much they're taking. So this is yet another challenge when you add grandparents to the tracking of this use of intermittent leave. Very complicated.
Thank you very much. You looked ahead into your crystal ball and saw my second question. So thank you very much.
Thank you, sir. I have Senator Guerin, followed by Representative Bradstreet, then Drinkwater and Gear.
I hadn't lowered my hand earlier. Sorry about that.
Oh, that's all right. No, thank you. Representative Bradstreet, then Drinkwater, please.
Thank you, Mr. Chair, and thank you, Mr. Gore, for being here. Again, this is not a question so much as an observation. And we're talking about how we need to be, I think, as specific as possible when we set policy. I'm looking at a footnote under Attorney Young's presentation or testimony. And in it, he says there are some limited situations where the FMLA has been found to extend to grandparents, though not expressly mentioned in the statute. I think he's referring to federal statute here. These include where a grandparent is the legal guardian of a grandchild, stands in a local apprentice to the grandchild, or where a grandparent is providing psychological or emotional support. So I just wanted to, have a constant reminder for us. We need to be as specific as possible unless we want courts to decide. I'm thinking and looking at it, it's probably a court decision because something was left open to interpretation and maybe wasn't intended. That's all I have to say. Thank you.
Thank you. Representative Drinkwater and then Representative Gear, please.
Thank you, Mr. Chair. I got a question for Mr. Gore. Mr. Gore, when you folks take a position on a piece of legislation, can you explain to me the process that the chamber uses? Is it upward? We send out questionnaires and then we do an opinion poll? Could you just briefly hit upon that for me?
Certainly, be glad to. We do have policy committees that are made up of our members and review each of these bills and help us discern what our policy is going to be. And we meet and review every single bill. In the case of this bill, I was not able to do that because of the time frame, which is why I'm here neither for nor against, not taking a position one way or the other, but that's how we do it.
Thank you, sir. And maybe this is a question for our workshop for the legal analysts. I'm hearing a lot about full-time employees. I'm curious on definition of how many hours one must work for full-time employees, because I know a lot of school districts have a different definition of how many hours one must work. And my question also for the legal analyst for the workshop would be, what rights under the Leave Act do part-time employees have? So thank you, Mr. Chair.
Thank you. Representative Gear, please.
Thank you, Mr. Chair. Mr. Gore, I am curious as to your perspective on the issue of sort of documentation or definition of a grandparent's role, and would there be a need from the standpoint of the employing business to have a prior understanding of that relationship and of that responsibility before FMLA is enacted or used by that employee?
Yes, I again, people have to assert their rights under the law to access the leave. FMLA, for example, is one. And so presumably the employer would hear from the employee, in this case, the grandparent, and say, I'm a grandparent and I'm asserting my FMLA rights because I need to be a caretaker to my grandchild. And again, at this point, I don't think the employer would have, there's no way for the employer to be able to verify that. And again, I don't know what, again, I would ask your analysts this, what right does the employer have to ask that question of the individual, for starters? I'm going to add one thing as we've discussed, and you asked me some questions this morning, and that is the easiest thing to do in this may be to include grandparents when the parents are not either deceased or they've been their parental rights have been terminated. In other words, right now, if a child is sick, the parent has the right to the act. I think the double dip that the sponsor was seeking was to make sure that you didn't have a parent flow into the grandparent. So the cleanest thing to do is just say, when there's no parent, then the grandparent qualifies for the FMLA. That's a suggestion that I might make to you. But you're going to have to parse those words with your analyst.
Yeah, thank you.
Any other questions? Well, thank you very much, sir. I appreciate you being here.
Thank you. You'll see me again.
Looking forward to it.
Bye-bye.
Have a good day. Bye. Alyssa, I think we only have
Stephen
one
Bailey.
more. I'm sorry?
Stephen Bailey.
Stephen Bailey would be the first and only against the proposal, is what I see. So we could get Steve on. Good morning, Mr. Bailey.
Good morning. Glad to be here today. Thanks for having me. I think I have my audio up and video. Can you hear me okay? Okay, terrific. Thank you. Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. I'm Stephen Bailey, Executive Director of the Maine School Management Association. I'm here today testifying on behalf of the legislative committees of the Maine School Superintendents Association, and also on behalf of the Maine School Boards Association. The Maine School Superintendents Association is in opposition to LD 61. The Maine School Boards Association was divided on this bill with 4 in favor, 3 opposed, and 1 neither for and against. So you can see in terms of our groups that discuss these bills, this particular one gave us a great deal of consternation in terms of, okay, how do we approach this? School leaders are well aware and appreciate that grandparents often step in to care for grandchildren and do so on a regular basis. This is true not only with the prevalence of COVID, it also is a reality in areas where opioid and addiction are widespread, a crisis we know will outlive the pandemic. The issue raised by school boards and superintendents is grandparents are not the designated guardian under the scenario the bill describes, and the legal definition has ramifications in school. Title 20A, the statute that covers public education, has multiple references to notification or permission from parents or guardians. The topics range from required vaccinations to excused absences and are very much part of the special education process when it comes to creating individual education plans or IEPs for students. We also are concerned this bill would allow grandparents who are teachers, and we have many, take time off to care for children so the child's parents can go to their jobs. We believe having teachers in front of students, either in person or through remote learning, is essential right now. Teachers are critical to our children's academic success, and the pandemic already has cut into valuable learning time. With the language clarification the sponsor provided this morning, who also is a former superintendent of schools, we do think that having this language applying to grandparents who have direct and primary responsibility for care of a grandchild would bring further clarification to the bill. We also would like to make sure that within the information that is included with the current legislation, that this deals with serious health conditions, and it shouldn't be for primarily only caretaking situations where a grandparent might be taking care of the child. So as you can see, with the 2 different groups that I represent here today, with some in favor, some in opposition, some in favor, some unable to make up their mind, it's still one thing that I think still needs to have much greater clarification. I've enjoyed hearing the questions to the committee and by the committee today, and we'd be very interested in following this bill as it takes further shape. Thank you very much, and I'd be glad to take any questions.
Thank you, Mr. Bailey. If you wanted to take a minute to just, as again, somebody we're going to see again on future bills, take a minute to say a little bit about yourself and the groups that you represent. You touched on it in your testimony. We wanted to give you a moment if you wanted to expand on that.
Certainly, thanks very much. Yes, Steve Bailey, Executive Director of the Maine School Management Association, as well as Executive Director of the Maine School Boards Association. Often, I also may represent you in relationship to the Maine School Superintendents Association. The Maine School Management Association is the umbrella or the support organization for both the Maine School Boards Association as well as the Maine School Superintendents Association. Each of those associations has their own independent legislative committee. We meet and do discuss each of the bills that do come before you. There's the other group too, Maine School Management Association, at times that I may come and just represent that particular organization. MSMA operates 5 different insurance trusts for our members. Our members are the school boards of the local districts across the state. We represent 1,800 school board members across the state, about 260 public school boards, as well as the superintendents in MSSA within their organization. So that's about another 150 superintendents that we would be representing through that particular association. So yes, we do come before you fairly often. And some of the issues that we speak of, obviously, are related directly to as it affects education in our school districts and school employees. Thanks for allowing me to be here today.
Thank you, sir. Representative Cuddy has a question.
Thank you very much, Senator. Thank you, Mr. Bailey, for your testimony, and it's good to see you again, even over the Zoom. The Zoom. Oh, that's like a grandfather way of saying that, isn't that? I just said the Zoom. I'm going to have to use the Google later to see if I can look up what age group says that. But it's appropriate, you know, we're talking about grandparents in the bill, so that works. So I was a little confused, and I'm hoping you can straighten me out on, in your testimony, you talk about that grandparent is not the designated guardian. And in Title 20A, you make reference to the fact that often notification or permission is required from a designated guardian. If they're added to FMLA, they're not going to receive the ability to approve of a child getting a vaccination or allowing them to go on a field trip or something along those lines. They're going to be able to take time off to work with or to take care of a sick child or something along those lines. I feel like I'm missing something there. Can you fill in that knowledge hole for me?
Well, actually, I think you've clarified it some in terms of there are situations where the grandparent would be the designated legally appointed guardian. And so in those cases, the grandparent would be the person able through 20A to be able to make those decisions that were talked about in testimony. And we would be in agreement with you that in this particular situation, the primary, as Representative Stearns talked about, the grandparent with direct and primary responsibility, not necessarily having legal guardianship, would have the responsibility and care of the grandchild and would be eligible, understood through this particular bill as it's been presented.
Thank you. Representative Rader, please.
You are on mute, Representative Rader.
Sorry, you missed the thank you, so thank you, everyone. I have a question along the lines of Representative Cuddy's question regarding clarification of part of your testimony, Mr. Bailey. You mentioned grandparents who are teachers possibly taking time off to care for the grandchildren while their parents were working. Currently, the FMLA does not apply to that. Am I correct on that? And
Correct.
Also, okay, thank you. And also, this is sort of for all of the discussion that we've been having today. When we're speaking of grandparents and FMLA, we're speaking of grandparents taking care of children in this, not necessarily grandparents. And if a grandparent is taking care of a child because their parent is the one who is ill, that's different than a grandparent taking care of a sick grandchild. So I feel like there are two prongs to that. If a grandparent takes time off because their child is ill, then that's a parent situation and a grandparent situation. But if a grandparent takes time off because a grandchild is ill, that's separate. If I'm wrong, please let me know. Thank you.
No, and I think what I'm hearing you say is it would be correct, because one would be the parent. I think this bill deals with the grandparent taking care of the grandchild who would have the serious health condition. That's my understanding of it.
Any other questions? Sir, I'm just going to ask this. I don't know if it's not necessarily a question. I'm hearing feedback. I'm sorry. Is that us? All right, we'll try this again. So it's just kind of an observation that I'm just finding it rather curious that Maine school management and superintendents, to me, this bill is looking at specifically targeting the caring for children, which is we have found is a huge issue with this pandemic, child care in particular. But I just find it odd that people that are in the kid business would find opposition to this.
Interesting question, and one that we did actually discuss in great length as we had this particular conversation, because yes, we are in the child support business. In this particular instance, and it's been noted several different times across these last several months, where school districts have had to either move to remote instruction or be closed because staff was not available to be able to conduct learning based on how their plans were set up within their school district. So substitutes right now are in great demand. There are multiple shortages of qualified people to be able to help out in these situations. So that was the greatest concern, I believe, that was expressed, making it very difficult for superintendents to come right out and support this. While indeed they certainly support the concept of making sure that students are cared for, especially with the students that have a serious health condition, cared by quality health, not health, but family providers.
Thank you, sir. Any other questions for Mr. Bailey? And thank you, sir, for being with us today. We appreciate your time and good luck moving forward. Alyssa, anyone else in the waiting room?
No, I believe he is the last one for LD 61.
Well, having heard all the testimony that I think we'll hear today on this, I like to close the discussion on LD 61. Thank you. Next up is, let me grab it. Will be LD 111, and that is an act to allow career educators to retire without penalty. That is being presented by Representative Toole of East Machias. It's co-sponsored by Senator Moore and Representatives Carlo, McCray, and Stearns. Representative Toole.
Well, thank you, Mr. Chairman. Can you hear and see me?
I can, sir. Thanks.
Thank you, Senator Rafferty, Representative Sylvester, distinguished members of the Labor and Housing Committee. My name is Will Toole. I represent Cutler, East Machias, Eastport, Lubec, Machias, Machiasport, Roque Bluff, Whiting and Truscott Township in the 130th Maine Legislature. And I'm here today to present and speak in strong support of LD 111, an act to allow career educators, my screen just went, so there we go, to retire without penalty. LD 111 rewards educators who have taught generations of Maine children by allowing them to retire before the normal retirement age if they have 35 years service. 35 years in a profession is a long time. It's a testament to a person's conviction, dedication, and professionalism. Just as tens of thousands of healthcare workers are being recognized for their sacrifice across the state, so too must we reflect on the men and women who have given their lives to providing the best education possible under extremely challenging circumstances. The longtime educator has endured budget cuts, school consolidation, a constantly changing regulatory environment, new training standards, new teaching standards, mixed messages from federal, state, and local policy makers, as well as parents and community members with ever-changing demands. All of that was true before the pandemic brought us hybrid learning, remote learning, distancing, and mask requirements in schools, professional development time being consumed by COVID-19 preparedness, even more regulatory uncertainty, and the stress of serving an all-expectant public. While I have never taught school or managed one, I regularly eat lunch with teachers in my district, and I hear these complaints every day. They know their students and their students' families, but burnout is real, and everyone is struggling with the current situation. Some who have been in the field for decades would retire if they were of retirement age, but the loss of benefits is too great. The loss of the penalty for retiring is too great currently. This legislation would fix that. Veteran educators who wanted to retire could do so. If they wanted to come back to the field, they could do that as well, with the understanding that they pay into the retirement system while they're working, so that we avoid perceptions of double dipping and maintain the delicate balance in Maine's retirement system. I am joined here today by current and former state educators who have an infinitely greater amount of knowledge on this topic than I. And while I am happy to answer any questions, I think your conversations with them will be much more beneficial. Thank you for the opportunity to speak today and represent educators in my district and beyond who have paid their dues.
Thank you, Representative Toole. I don't think we're going to let you off the hook without any question.
That's okay.
I know you do have some experts, but just in case.
Sure.
Does anyone have anything for Mr. Toole specifically? I think you are going to escape, sir.
Okay, well, thank you all.
All right. Thank you. We do have some folks that are here with us. Is in the room, Alyssa, in order. I think I have John Kaczynski. I'm not sure if John's.
Mr. Chair, I think Representative Stearns is here as a co-sponsor, but.
Oh. Thank you. Mr. Stearns, if you would, I'm sorry, I thought you might have been transfixed on my screen from earlier today.
Thank you, Senator. I think the Education Committee may have disowned me already because I'm supposed to be. I haven't figured out how to buy Zoom.
I've been told you can't. You need to be. You need to get out of one and into another.
If you can, I don't want to know how to do it. Trust me, this is stressful enough.
Yeah.
Might I go ahead?
Yes, sir, please.
Senator Rafferty, Representative Sylvester, and distinguished members of the Joint Committee on Labor and Housing. I'm Paul Stearns, and I represent House District 119 of Piscataquis County, and I'm here today in support of LD 111. Teachers, quote, normal retirement age is 60, 62, or 65, depending on when they started service. And depending on which one of those groups you're in, which one of those cohorts, if you will, for each year that you retire at less than that normal retirement age, you're penalized by, for some groups, 2.5%, but for the 62 and 65-year-old cohorts, it would be a 6% penalty for every year. Let's take an example of a teacher that has age 62 as a normal retirement age. They start teaching when they're 22, and after 35 straight years of service, they make the decision to retire. Their pension amount will be reduced by 30% every month for the rest of their life. If their top 3-year average compensation happened to be $60,000, as a calculation example, this would result in a yearly reduction of $14,400 annually to a 35-year employee. Remember that when Maine educators supplement their incomes with other jobs that fall under Social Security, any benefits accrued under that system are greatly reduced by the federal government pension offset and the windfall elimination provision. It's pretty rare that a person stays in education for this length of time. It will become even more rare as young people weigh the benefits and challenges of becoming an educator when making a career decision. Until such time as we can move to a retirement system for educators that is both robust and portable, the least we can do is remove a significant penalty for an individual that has served students and the public for 35 years. And I'm more than happy to answer any questions that the committee may have.
Thank you, sir. This retirement has been a long and drawn out and pretty common issue. I know over my years in education, but I do see some questions. Representatives Cuddy, followed by Representative Gear.
Thank you very much, Senator, and thank you, Representative Stearns, for your testimony on. I did just want to ask, you have a lot of experience in the educational realm. I don't, but I know from testimony we heard last session from teachers that it is really hard to make it on the full retirement that a teacher can get, particularly when you've retired prior to your ability to transfer straight into Medicaid, because the state only picks up a percentage of the healthcare costs. So how do you see that, just from a personal experience level? How do you see that working for teachers? Do you think that that will impact the number of teachers who will try to take retirement at this earlier age, even if they can get their full benefit? The fact they'll have to give so much of it over to paying their own health insurance. Do you see that impacting the number of teachers who might take that retirement?
Yes, however, I think that the cohort of folks that are career educators is likely pretty small. And the only reason I say yes is under the current employment, under the current teacher shortage that we have. There will be folks that would say, hey, with no more penalty, I'm out the door, because it's a pretty good chance they're going to have to hire me because they can't find educators in the state of Maine. So that indeed would be an issue to consider. Again, I'd like to kind of go back to one of the pieces in my testimony, and there is a commission that has been working on this. I think it's imperative that we sort out a new and better retirement system for educators that allows for portability. The fact that someone's, for instance, believe it or not, I was a physical education teacher when I was 22 years old. And if I were to go to the age of 65, I'm not sure that my forward roll form would be too good when teaching gymnastics And after 35 or 40 years of instruction, that's an awful lot to ask. And the other piece is to compare that to other, game wardens, state police, et cetera. And you generally have a 25-year limit. I hope I answered your question.
You did. Thank you.
Thank you, sir. Representative Gear.
Thank you, Mr. Chair. Actually, Mr. Stearns, you touched on one of my questions right there. I was curious as to how this change and this retirement age for teachers compares to other categories of employees. It sounds like 25 years is what you said for other state type employees at this point.
Well, as usual, I may have spoken off the cuff, but that's an analyst would have to look at that. But in general, I know that it would be pretty rare to penalize a person for retiring way up into the 30 or 40 year category. I think for a long time, most of our categories were 20 years in, for instance, state police and those have been bumped up over time. And I think that mostly they're around 25 years now. But again, that's a layperson's view of that. That's my big asterisk.
Got it, right. I use lots of those asterisks myself. And then just a quick follow-up, Mr. Chair, if I may.
Go ahead.
Do you have an estimate, Mr. Stearns, of what percentage or what number of teachers in the statewide teaching population are at or approaching this 35 years of service?
I do not, but I'm sure there will be others that will weigh in on this that will have that readily available.
Representative Cuddy.
Thank you. And thank you, Senator. And this may not be a good question for you. I'm going to put it out there. And if you think there's somebody coming behind you who's better suited to answer it, please feel free to just suggest that.
There is.
What's that? Oh, yeah. Yeah. So the question is for anybody listening who may want to chime in on it, is how would this work with the sort of retire and rehire and policy that goes on? Where a teacher retires and then is hired on for another number of years, and they go back to work. That sort of just ran through my brain. I'm just curious about hearing if anyone has thoughts on how that would work.
Well, again, I in a previous question, I think tackled that a little bit. That's a tough call. You're trying to guess as to what people would do. My guess would be that under the current situation of shortages of administrators, various teachers in various fields, that may present a problem in this area. Folks might feel confident that they are going to be rehired, even though the law doesn't allow them to make a deal prior to retiring. They may feel very confident that their skills are going to be needed. So there might be a larger than normal, if you will, group that would say, "Hey, I'm gonna roll the dice and do this." If we were flush with applicants for jobs all across the educational spectrum, I think it would be less of an issue. And again, that's just a prognostications from Guilford, Maine.
Sure, and that doesn't. I'm sorry. Could I get a follow-up, Senator Rafferty?
Sure, go ahead.
Thank you. But that doesn't actually impact. It wouldn't likely impact the availability of teachers for schools, because what would essentially happen is the deal for the individual teacher would change, but the deal for the school system really wouldn't, because they would begin accessing retirement benefits, and then they would be locked in at their last level of pay. So the school system would sort of be held harmless. And we've heard in the past from MEPers that it's not a serious threat to their ability. Okay, you know what? As opposed to a question, that was me thinking out loud. So I'll end with, don't you agree, Mr. Stearns?
I think you're right onto it, Representative Cuddy.
Any other questions for Mr. Stearns? Are there any other co-sponsors waiting, Alyssa? Mr. Stearns, thank you very much, sir.
Those are the only two for sponsors and co-sponsors.
Okay. Are there any? I know there are, but I don't have the, I lost my order, but we'll hear from next then from folks that are for or in support of this bill.
Okay, so first up we have John Kaczynski.
Good afternoon, John.
Hello, Senator Rafferty, Representative Sylvester, other esteemed members of the Labor and Housing Committee. Can you hear me okay? Excellent.
Yes, sir.
Thank you. So nice to see everybody today. This is my first time testifying before any committee and look forward to working with everybody. Hopefully you have my written testimony already on this bill. I tend not to read the testimony, but I'll hit some main points. I regret not testifying now on LD 61. I thought I would save you all the time. Your previous bill, I submitted written testimony for that. But after hearing some of the comments from Maine school boards and Maine superintendents, I just want to highlight my testimony for that bill and that MEA fully supports that bill. So I'll go ahead and get started on my testimony. I just want to hit a few points really. Well, first of all, I'm John Kaczynski with the MEA. We represent the Maine Education Association. We represent 24,000 educators in our state, including thousands of teachers, Ed Tech 2s and Ed Tech 3s, and nearly 5,000 retired educators. And I feel very confident we could have had a very large turnout for this bill today. But I will tell you in our communications with members, while we have articulated that we intend to support it, we flag, and I flag in the testimony, some concerns about the bill that will likely impede its passage. But as Representative Stearns eloquently said, the current pension for teachers in some ed techs certainly needs improvement. And I just highlighted my testimony, the devastating cuts and changes that were made 10 years ago. In 2011, the legislature approved and the governor signed a 2-year state budget that drastically altered the pension system for new and current retirees, including creating what's called a new cliff. Some people call it the cliff and the rug because there's been a couple different changes that have drastically impacted educators in the MEPERS system. But the new cliff was created that folks cannot retire until 65 without penalty. And as Representative Stearns said, whether it's a phys ed teacher, or I certainly think of kindergarten teachers who may struggle to teach for 40 plus years if they enter the profession right after college. There has been quite a bit of work, as Representative Stearns mentioned, about a portable pension plan. We think this is critical. He mentioned GPO WEP offsets. These are Social Security offsets that penalize teachers, often severely. And when I say teachers, I also mean Ed Tech 2s and 3s who are in the plan. And I want to highlight Senator Maxman has a bill to recreate a task force to get to work on the redesign of a pension plan that we think our system needs. And that will be coming your direction this session. And we look forward to talking about that. For several years, MEPERS has convened stakeholders, including Maine Education Association, Maine School Management, the state employees, to look at a redesign that's hopefully Social Security based, that will address some of the GPO WEP offsets, and also make a plan that's more portable. However, I do highlight in my testimony for you the language from the Maine State Constitution. This is a constitutional amendment that was passed in the 90s, and I've highlighted a key section. Unfunded liabilities may not be created except those resulting from experienced losses. This language will, I assume, MEPERS, who we work very well with. I think they do a
Mr.
great
Kaczynski,
Yes.
if you could finish up your thoughts, and then hopefully we'll give you an opportunity to finish it with questions.
Thank you. So I'll finish up by saying we certainly have workforce shortages. I would be remiss if I didn't mention this could create more, and I'm certainly happy to answer any questions about retiree return to work. So thank you so much for your time. Thank you so much for your service. I'm sorry to go over. It's hard to see the screen and my testimony at the same time, but thank you so much.
We're all figuring it out. And Mr. Kaczynski, if you could take a moment, as somebody who, again, is going to appear before us several times, to just tell us a little bit about yourself and the members you represent.
Thank you, sir. So Maine Education Association is who I represent. I am the Government Relations Director for the MEA. It's my full-time job. I'm not a hired gun. I'm not a hired lobbyist. I work for the teachers and the educators of this state. They tell me what to do. They tell me what to say. And I try to be their best advocate that I can be for them. MEA represents educators in nearly every public school in the state. We represent bus drivers, custodians, school secretaries, guidance counselors, social workers, teachers, you name it. We also represent the faculty and other professionals and support staff at the University of Maine system and the community college system. We also, for some reason, represent Maine Public Radio, which we're proud to, Maine Public MPBN, which we are proud to represent as well.
Thank you very much, sir. Any questions for Mr. Kaczynski? Yes, Representative Bradstreet.
Yes, thank you, Mr. Chair, and thank you, Mr. Kaczynski, for being here. I think you were kind of cut off and you were going to make a point about the Constitution and you ran out of time. Could you expound on that, or did you have anything more to say about it?
Thank you, Representative Bradstreet. Great to see you via Zoom. Yeah, I think I covered everything. I put in my testimony, hopefully you have that, the actual language from the Maine State Constitution, which was a late 90s constitutional amendment. Anytime we talk about pension improvements, this constitutional amendment becomes an obstacle because it's going to require us to pay the upfront cost for any improvement, including a bill such as this. It has helped our pension system be among the most fiscally responsible in the country. And again, hats off to Sandy Matheson and her team in terms of the overall funding of the pension system, but it has prohibited improvements. And that's what makes the 2011 cut so devastating, because our ability to then fix those cuts or make changes is impeded by the constitutional amendment. That's partly the reason why we have focused quite a bit of time on making improvements to the retiree healthcare program. And those bills will be coming back this session. A bill by Representative Falkingham and a bill by Representative Collins, both designed to do the same thing, which is try to increase the state share towards retiree healthcare. And that has mostly been our focus because of the constitutional amendments provisions, which will make it harder to make pension improvements. I hope that answers your question, sir.
Thank you. Representative Sylvester.
Thank you, Mr. Chair. Mr. Kaczynski, I'm going to try to summarize my thought or my knowledge, which is limited, on the situation we keep touching on, which is if somebody retires and then comes back into the school system, and whether, and if you could expound on whether how this law might change the situation as I understand it existing right now, or if I get this wrong. So if I retire, as a school teacher, having met the years, whether or not I have any penalty, and then I meet my years of service at, let's just say 35, and then I re-enter the system, I am obligated right now to pay the same retirement into the system as if I had continued my employment, but I cannot add to my years of service. So if I teach 5 more years, I will not retire with 40 years of service. I will be collecting my pension at the 35-year level, and whatever I am paid up and above that would not include additional retirement into the system. Is that somewhat close to correct?
I believe it is, sir, and I believe Sandy Matheson or someone from MEPERS will be on to testify to just clarify that. But I think what you described is spot on. And the one point I want to make about this committee over the past years, in that 2011 budget, we had a provision that was tucked in that made retiree rehire much more challenging and difficult. And it was actually Representative Stearns and this committee over the many years since then that where we finally, I think every session we've had bills to fix that language because the limitations were so severe. The point I want to make about retiree rehire that sometimes gets missed, in order for someone, a teacher or an ed tech, to retire and then go back to work in the school district, first they need to sever their employment with the district. So in order to get your pension, you have to completely sever your employment. If I'm a social studies teacher at Brunswick High School, in order for me to retire, I have to notify them that I am leaving the profession. What happens, or leaving my job? What happens after that becomes completely the decision of the superintendent and the school board. If they choose to hire me back, they have to make that decision to hire me back. And most districts are using this for two reasons. One, and I mentioned this in my testimony, widespread and systemic shortages. The number of shortages in our schools has grown. The department every year produces a list of shortage areas. That list has grown substantially since this time. But a lot of times for school districts and for educators, they will work out a retiree rehire arrangement that benefits the district because it might save them money, particularly on health insurance costs. And it certainly benefits the students because you've been teaching for 35 years. Hopefully you're pretty good at what you do. You've had your days in the classroom, and hopefully you've learned and benefited from that, and you're going to impart that onto your students. And then it benefits the educator because a lot of times they might not come back full-time, might be a partial employment. I know, for example, in many years in one school district way up north, they were struggling to find a physics teacher. And there was one gentleman who the community loved. He was an awesome teacher, and he kept teaching for many years after retirement because he enjoyed it, the district needed him, and it was cheaper for everybody. I hope that answers your question on the specifics. I would just encourage someone from MeetPers to answer that, but I believe your assessment is right, sir.
Thank you, sir.
Senator Mirmont.
Thank you, Mr. Chair. I just wanted to make sure, I mean, I heard some of the different pieces. I'm going to kind of sum up. So if someone decides to retire early and get their pension, which they have paid into and the state has to pay into for each teacher, each employee, they would either go back and get hired if possible, or another person would be hired if the position needed to be filled, and the person who was hired would be paying into their pension and would have the state portion of the pension. They only get what is owed to them, and they're only required to pay what anybody would, and there's no guarantee they go back. Does that sum it up properly? I'm trying to see where the advantages is to someone, except that if they have an opportunity to retire, and yet there's a need for teachers and they can go back and they can finally make enough money to live the rest of their lives without having to die early to be able to afford to live on a teacher's retirement. Where's the negative in this? That may have been a little bit of an editorial, but how's my thinking on the first part?
If I can, sir, I feel like we have gone down this rehire, retire road on this bill, and that's not the real impetus for this bill. I think the real impetus, I think most of what you said is spot on, or if not exactly spot on. But I think this bill is just trying to recognize that if you work for 35 years in a school, you should be able to retire without penalty and with dignity. And what Representative Stearns mentioned, and which I tried to mention is my testimony, is throughout the years, we've created different cliffs for people to retire. So you could be at 35 years teaching and still be seeing the 6% penalties that Representative Stearns mentioned, or the 2% penalties, depending on where you fall in the pension system. So, I think the retiree rehire is one component of it, but I think what this bill is just trying to recognize is if you taught for 35 years, that should be sufficient for you to retire without penalty, and that's currently not the case under the MeetPers system. Does that help, sir? You're on mute, sir.
And a follow-up, Mr. Chair?
Yes, sir.
Oh, thank you, Mr. Chair. And this part about if you, maybe the retire rehire part doesn't matter, but did I hear that even if you're rehired and you're paying into your retirement, you're not getting credit for it? Doesn't Social Security give credit if you retire and you pay in, well, if you retire early at 62 and you pay till you're 66 and something, if you're earning money during that period, you're credited with that, even though you retired early. And when you retire at full retirement age, you get
increased money over what you would have because you earned during that period. Does that directly compare?
I think it does, and I would just ask that question be asked of MEPers, just to be absolutely clear on that, but hopefully they will be testifying on this bill. Thank you, sir.
Thank you. Representative Gear.
Thank you, Mr. Chair. Mr. Kaczynski, I have a question as to how the retirement age of 35, or after 35 years of service, how does that compare to other states?
That's a great question, and I don't have that at my disposal. I will try to see if I can ascertain that. I will say what states do is all over the place in terms of this is a defined benefit plan, MEPers, not a defined contribution plan. So we have a variety of states around the country who maybe have migrated to a defined contribution plan. There was even one case, I think in Alaska, where they moved to 401ks for their teachers and public employees. I can look into that, but I don't have that at my disposal right now.
Thank you. If you could, that would be great.
Yes.
Any other questions for Mr. Kaczynski? Thank you very much, John.
Thank you, sir.
Appreciate it. Have a great, thank you. We do have other folks that are, I believe, are in the waiting room to speak for. Is it Scott Porter that's up next?
Yeah, I just promoted him.
Thank you.
Mhm.
Good afternoon, Mr. Porter. Can you hear us?
I can.
Thank you, sir, and welcome. You're up.
All right, thank you. And good afternoon. Senator Rafferty, Representative Sylvester, and other distinguished members of the Labor and Housing Committee. I'm Scott Porter, Superintendent of Schools in AOS 96, which is 11 towns in the Machias area. I'm writing in strong support of LD 111, an act to allow career educators to retire without penalty. The current Maine educator retirement system was dramatically changed in 1993, which has been mentioned, when the penalty for early retirement was changed from 2.25% to 6% per year. This dramatic change happened to educators that were hired between 1983 and 1993. So you could have people in the system for about 10 years that had the promise of a 2.25% penalty that were kicked out of that and put into a system where you ended up with a 6% penalty and an age that went from 60 to 62. And now, of course, in 2011, that was changed to 65. So, so people had that promise. That just doesn't seem fair. I know that about 10 or 12 years ago, there was an effort to change it from a 6% penalty to a 3% penalty. That was not successful. But I believe LD 111 is the solution to fix this particular problem. LD 111 will help remedy the issues caused by that 1993 retirement law that I just described. In addition, it will work as an incentive for young people to choose education as a profession. Under the current retirement law, a teacher coming out of college would work for approximately 43 years before being able to retire without a penalty. This bill allows retirement without a penalty, as you know, after 35 years of service. And LD 111 does require in the language that those that retire and are rehired would contribute to the retirement system without ever getting that money back. And I think the reason for that is we know that it's going to cost money, of course, for this to change.
And I hope we'll find out how much, but it would strengthen those that are rehired, would strengthen the retirement system if they paid into it without the promise of getting that back. I know some people think that tons of people will get out of education. I think some would, but in the end, most people stay till 65 because of the health care needs. So I hope you'll support LD 111. Thank you.
Thank you, sir. Any questions of Mr. Porter? I'm not seeing any. So I just want to say thank you, sir, for being here today and making yourself available, and good luck moving forward.
Thank you.
And heard from Mr. Toole.
Next, we have Stephen Bailey.
Good afternoon again, Mr. Bailey.
Yes, good afternoon. It's nice to see you all again. I'm still Steve Bailey, Executive Director of the Maine School Management Association. Give greetings to Senator Rafferty, Representative Sylvester, and members of the Labor and Housing Committee. I'm testifying this afternoon on behalf of the legislative committees of the Maine School Boards Association and the Maine School Superintendents Association in support of LD 111. As you've heard, this bill would affect the so-called CLIF employees working as teachers and administrators in our schools who did not have 10 years of service when retirement law was changed in 1993 to help balance the state budget. Those employees have to wait until they reach 62 years of age before they can retire with full benefits. If they retire early, as you've heard again, they face a 6% reduction per year in their benefit. This requirement has not changed while the demands on public schools have steadily increased. Educators and administrators feel obligated to do much more as the social, emotional, and physical needs of our students grow. That was true before COVID. Now those needs have grown exponentially and affect more of our school population. And the growing workload has a direct impact on the physical and mental health of the adults in the building. LD 111 recognizes that reality. It makes retirement with full benefits an option for our people who have 35 years of service. We do not anticipate a rush to the door, though. We do expect that those who feel they can no longer do the job with the same energy and passion will see this as a welcome option. We've talked with our partners in public education with whom we meet weekly and have acknowledged this bill seems in conflict addressing Maine's teacher shortage. We want to keep teachers and administrators who want to remain in the profession but give a viable option to those who don't or can't. We also understand that this will come with a high fiscal cost and may need to be amended. What we're hoping is it starts an earnest discussion to deal with a problem we can no longer continue to ignore. So with that, I would welcome any questions.
Thank you very much, sir. Any questions at all, please, for Mr. Bailey? Not sure. No, I think don't see any, sir. So thank you very much.
Okay.
Appreciate you being here today. Again,
Thank you.
and have a good afternoon.
You as well.
Melissa.
So he was our last one for 4. We have no against. We do have one neither for or against, though.
Thank you very much.
And that would be Kathy Moran, who I'm promoting now.
Good afternoon. Can you hear me?
Yes, I can now. Thank you very much. Good afternoon. How are you?
I'm good, thank you.
Good.
Senator Rafferty, Representative Sylvester, and members of the committee. My name is Kathy Moran. I'm the Manager of Actuarial and Legislative Affairs for the Maine Public Employees Retirement System. Before I begin my testimony, I want to just briefly mention that the system has recently launched a new page on its webpage where you and all of our members, employers, stakeholders can access information about pension-related bills in the session. And we just wanted to put that little bit of a plug out there so people know where they can access information where we're not being able to come to meet with all of you in the committee room. Regarding LD 111, Maine PERS is testifying neither for nor against. We're here to provide information and offer any assistance to the committee that you might need regarding this bill. Under current pension plan provisions, there are two ways by which a teacher becomes eligible to retire. One way is by completing 25 years of service, and the other is by reaching the applicable normal retirement age, which is age 60, 62, or 65, depending on service requirements at specific dates set in law. A teacher who reaches 25 years of service prior to reaching normal retirement age may retire with a reduction, which has been mentioned is typically 6% for most teachers now, for each year that the person is below normal retirement age. LD 111 proposes to allow teachers with at least 35 years of service to retire with an unreduced benefit regardless of their age. It also retires retired teachers who return to work to pay the member's normal cost during the period of reemployment, which the rate is currently 7.65% of earnings. Under the current provisions, reemployed teachers do not pay member contributions, nor do they accrue additional benefits. LD 111 will have a fiscal impact because the Constitution does not allow the creation of new or additional benefits unless immediately and fully funded. New benefits are created under LD 111 because a teacher would be receiving benefits for more years than currently accounted for in funding, creating an unfunded liability. We've worked with our actuary, and we estimate the approximate cost to be $83 million increase in the UAL, and that's the amount that would require upfront funding at the time that if the bill were enacted. We also estimate that there would be an ongoing increased normal cost associated with this bill of about $1.6 million per year. And that concludes the testimony, and I'd be happy to answer your questions, and certainly will be available at your work session.
Thank you very much. Mr. Representative Drinkwater had his hand up, and followed by Representative Cuddy, please.
Thank you, Mr. Chair. Glad that you noticed I jumped in there early. I retired from Social Security. I retired at the age of 62. Social Security said I should have worked until I was 65. So therefore I paid a penalty for retiring early. Can you explain to me the difference between what happened to me in Social Security and what we're talking about with teachers? Are we talking about them having to pay a penalty like I had to pay a penalty and not receiving my maximum Social Security?
So we don't look at it as a penalty, as that being the correct term in the context of a defined benefit plan. And that's because what's happening is that a person who retires at, say, 55 versus age 60 is going to receive a benefit for more years than a person who retires at 60. So basically, the benefit is discounted back so that on what we call on an actuarial basis, which is how a defined benefit plan is funded, the person ultimately receives the same benefit over their lifetime, but they may receive less for longer years than they would receive more for shorter years. So it's a reduction in terms of early retirement, but it's a reduction to basically smooth out the benefits that person would otherwise be entitled to over the course of their lifetime.
So what you're saying is this is similar to what Social Security does.
I'm not familiar with exactly what Social Security does. I know they have reduced benefits at different ages. So in that regard, I would say it is similar.
Thank you.
You're welcome.
Representative Cuddy, followed by Representative Bradstreet.
Thank you, Senator Rafferty, and thank you, Kathy, for being here today to help us work through some of this. You mentioned two separate financial figures. One was an upfront cost, I think it was 83 million, and then there was an ongoing cost of 1.6 million, I think you said.
Correct.
If my understanding of the constitutional amendment that was passed that limited the ability to make changes prospectively is that all the costs had to be paid for upfront. So how are there two separate costs?
So in funding a defined benefit plan, there are two components. One is the unfunded liability cost, and one is the normal cost. So the normal cost is the cost that is paid on an ongoing basis. That basically is funding the benefits that are being earned in that year as they're being paid. The unfunded liability cost, in this case, the $83 million, is the amount that it would cost to allow all the teachers that are currently in the system who ultimately would be impacted by this bill, the value of their service that they've earned to date becomes increased under this bill, because we've been expecting that they'll retire at normal retirement age, for example. Versus being able to retire earlier. So we're funding on a certain premise here. And so the unfunded liability cost is the piece that would get you basically up to speed so that all of those people could in fact retire out the door at 35 years. The normal cost is the cost that it would take to continue that provision into the future. So what you're funding for into the future is for the teachers that are there now and the teachers that are here tomorrow could also retire under that provision, and you're paying for that as you go along versus having to catch up for the cost for all the teachers that are currently in active service. Is that helpful?
Yeah, that was very helpful. Thank you very much.
I just saw a question pop up from Senator Guerin, and I don't know if I should respond to that now, or this is my first time Zooming on a hearing also, so.
Are you seeing that on chat?
Yeah.
Well, let's go through with the hands up first, then we'll get to
Okay.
it. All right. Representative Bradstreet, then Representative Sylvester. And
Yes. Thank you, Mr. Chair, and thank you for being here, Ms. Moran. Yeah, my situation, I'm pretty much like Representative Drinkwater. I'll be paying a penalty for retiring at 62 for the rest of my life. But anyway, aside from that, could you briefly explain the difference between a defined benefit plan and a defined contribution plan? Because I know there's been some controversy recently regarding some state employees. Thank you.
Sure. So a defined benefit plan is the primary plan that we administer, and it's a plan where a person can basically plan on, simplest terms, a person can plan on the benefit that's going to come out of their pension, and that is because it's formula based, set in statute. So a person in our plan typically earns 2% of their average final compensation for each year that they're in the system. And so that's the benefit they're accruing in a defined benefit plan. In this plan, the member takes no risk, for example, as far as the market. The employee contribution rates are set by statute. So they're paying in a set amount over the course of their employment. They're earning a 2% accrual rate based on their average final compensation. And that's the benefit that in terms is defined for them when they retire. A defined contribution plan is a plan that is as you know, market-based. So you pay in as a member, as a participant in those plans. You pay in your contribution. You may or may not have an employer match, for example, going into that. And then what you get out of it is determined based on what your fund balance essentially is at the point that you retire. So your investment in that plan is it's in the market, and you're absorbing the risk of that investment. So you'll have gains and losses personally. And at the point that you retire, depending on what your plan is and what your contribution is into that plan, that's what sets what you're able to draw out of that plan. So maybe may or may not be as dependable, reliable as it's not as certain for sure as a defined benefit plan at the point that you retire.
Representative Sylvester, then Gear, and then Senator Guerin, I guess. Well,
Thank you, Mr. Chair. Yeah, and I would just remind everybody to make sure that they are asking their questions live and online and not in the chats. The chat should be used for just sort of administrative questions and those sorts of things. So I have two very quick questions. Thank you, Kathy, for being here. Sure. And my first one, the numbers that you came up with, were you basing that on the normal number of retirees per year in the school?
So the number is obviously calculated by our actuary, and so they are going into their systems and looking at all the teachers, active teachers, and what the assumptions are. So there are assumptions about when people will retire and at what age and what their benefits will be and what their salaries will be and that sort of thing. And so we're looking at, they would look at the population as a whole and the assumptions that they use for all the various factors in an actuarial world to determine what the costs would be based on those assumptions to fund this kind of a provision.
Thank you. And then if I may, Mr. Chair, just another quick follow-up.
Yes, go ahead.
And I threw that out there because it was the first time we heard actuary, so I thought I would give you a chance to because we'll hear it again. And then, but secondly, I just want to say, my understanding in terms of the difference between Social Security and somebody in the state plan is that if I had been working in the private sector collecting Social Security and then went into public service, whether for a school or a state, is that I would be penalized according to the current state law for the amount that I was receiving from Social Security vis-a-vis my state retirement. Is that correct?
So it actually works in the reverse.
Okay.
MainePERS doesn't offset a regular service retirement benefit against benefits received from Social Security, but Social Security, and this is where you hear about the WEP and you hear about the GPO, the different offsets that Social Security applies. And they offset depending upon a person's contribution or non-contribution to the Social Security program and how long they've done it. There's a number of factors that go into when they do or they don't offset. And if something you're interested in, we can certainly, Social Security publishes some fact sheets on their website, and it's something we on our website actually link to because we get this question all the time. And we certainly could share that information with you if that would be helpful.
That'd be fantastic. And maybe by the time I'm done legislative service, I'll get that one right.
Thanks very much. Representative Gear is up next.
Thank you, Mr. Chair. Ms. Moran, the question I have, I asked earlier, but I think you might be the right person to answer it. How does the length of service requirement for teachers under the MainePERS system compare to the length of service requirements for other categories of state employees?
So it varies. So there's the teacher plan, and the teachers and most state employees actually have exactly the same requirements, and they're under what we call the state regular plan, and that's a 25-year plan with the normal retirement age of 60, 62, or 65, again depending upon service credit. There are a number of groups of state employees, typically law enforcement-based employees, who are in what we call special plans. And you'll hear a lot about that this session because there are a number of bills that are likely to come before you to talk about various groups who want to be covered under a special plan. There are different special plans, and again, this is something I think we provided in the briefing that Sandy Matheson, our executive director, did. I think it was last week. There was information in that presentation that set out some of the different requirements for the different groups. But there are plans that provide typically 25 years of service for those groups, but typically either a lower or no specified retirement age. So for example, state police can retire with 25 years of service, regardless of how old they are. And so there are different special plans based on those, typically, like I said, law enforcement positions that allow for an earlier retirement without having to take as much of a reduction for retirement or taking no reduction for retirement. And we can get you more information on that comparison, just so you can look at the side by side.
Yeah, that would be helpful. Can I just have a quick follow up on that, Mr. Chair?
Yes.
And just this, I'm trying to make sure as I kind of try to drink in all this information that I'm understanding it. I thought that the teachers had a length of service time of 35 years to retire with full benefits. Did I miss here?
The bill proposes to allow teachers who complete 35 years of service to retire with no reduction. The current law is they can retire with 25 years of service. If they retire below normal retirement age, then they do take that reduction. So it's 25 years is the current plan, but if they're below normal retirement age, they take a reduction. The proposal is you reach 35 years and you can retire without a reduction.
Okay, thank you.
Is Senator Guerin still there?
Yes, I am. And I do have a question. May I proceed?
Yes, followed by Representative Drinkwater, please.
Thank you. I wanted to write down the number, Ms. Moran, that you gave out for the cost of the program if we did enact it.
Sure. So I'm hoping you received my written testimony. It is in there, but the unfunded liability cost is $83 million. That's the upfront cost. And then the estimated ongoing normal cost is about 1.6 million per year. And just to speak a little bit more on that, right now, so the local school departments pay the normal costs for teacher members. So that is the additional cost that would be borne by the local units.
Both of those figures would be borne by the local communities.
No, the state pays the unfunded liability for teacher members, but local school departments pay the normal cost. And so the $83 million is the cost that the state would have to pay. And then the $1.6 million is really the locals pay the normal cost as a function of payroll. So they would pay a higher normal cost rate against their payroll as they submit information to us. And we equate that to be about $1.6 million.
1.6 would come from local districts then.
Right. And that's an annual cost.
Okay.
That's the additional normal cost they would be paying.
Okay. Thank you.
You're welcome.
Representative Drinkwater, please.
Thank you, Mr. Chair. I see in your testimony, you're saying under our Constitution that if we establish dental benefits, we have to immediately and fully fund what we're asking for, and you're estimating $83 million. Also, here's my question. My question is, if a lot of teachers burn out and they leave after, let's say, 10 years. If a teacher leaves education after 10 years, can they sweep their money from Maine State Retirement over to a different retirement system?
They could roll their money to a qualified plan if that's what they would like to do. Depends on what the receiving plan is, but people do withdraw their money from our system on a regular basis. In some situations, people who vest will leave their money in the system and they'll come back and receive a benefit when they reach retirement age. But others who leave the system will withdraw their money and often will roll it into another qualified plan.
And from what I understand also, that if somebody's worked in the private sector, let's say for 10 years, and they became an educator, they cannot sweep their money from Social Security into Maine State Retirement. Do you know that to be true?
I do know that to be true. First of all, so you never can withdraw your money from Social Security in the way that you're describing it. People can't refund their money from Social Security. It goes into the federal program and it stays there. And so there's no ability to do that. There's also, if you're talking a private retirement system, so somebody's working in the private sector and they're in a defined contribution plan, for example, and then they come to work for the retirement system, they can't just simply sweep that money into the system unless they have the ability to, as we call it, purchase service. So if they've been in a situation where there's service under certain requirements that they're able to buy, then they could use those monies to roll over into our system to make that purchase. But they can't just simply sweep the money into our system.
So this is a very unique system for Maine State Retirement. Do you know how many other states mimic this sweeping out if you choose to?
This are you referring to the refunding of money, or I mean, this is a typical defined. This is how a typical defined benefit plan runs. I mean, it's bound by there are federal laws, more so than state laws probably, that govern how a plan can be a qualified pension plan. So there are lots of requirements that we have to follow to make sure that our plan is qualified, and that's typical across defined benefit plans, public defined benefit plans, which pretty much every state has a public pension.
Thank you.
You're welcome.
Thank you. Sorry, you probably saw me take a phone call. Saw my phone light up, a constituent concern, so my apologies. Any other questions? All right.
Could I answer one question that was asked to a prior person, just to clarify some information?
Absolutely.
I think Representative Sylvester was looking for some clarity about how retire return to work currently works. And I think you indicated your understanding was that the person who retires and goes back to work pays into the system. And that's not the case. And I may not have heard you correctly. So I'll stop there and see if that really was what you thought was working, how it was working.
Thank you for that. Yes, no, I thought in previous testimony from last night that we had heard that people would be paying in, but wouldn't be able to actually benefit from the money that they were paying in. They would stay at the same retire because they were withdrawing already. So I appreciate that clarification.
I think what you describe is what would happen with this bill. I mean, currently people who return to work don't pay into the system. They don't receive any additional benefit, and they stay receiving the benefit based on, when they did pay in. What this bill proposes to do is to have the person who's returned to work, excuse me, pay in what their normal costs would otherwise have been into the system. And I think I heard somebody else who testified suggest that the purpose in doing that was to strengthen the funding and to not cause any concerns with the system in terms of the funding level. So this bill does propose that. The other thing I would say about return to work, I think I heard somebody say that the system in the past has testified that the system doesn't have concerns about retire, rehire, and I know that's not really what this bill is primarily about, but I just want to be clear that the system's view, and I think we've consistently stated this over the last few years as retire, rehire bills have come up, is that if laws were to change in such a way that retire, rehire were to become used much more than it is now in terms of a practice, then over a longer period, it could in fact cause funding issues or change cost issues with the plan because you're changing kind of the demographic when that starts happening. You have people who are coming into the system and not paying in, and you potentially are hiring more people at the higher end and less people at the lower end in terms of salaries than ages. So there's a lot of moving parts when it comes to retire, rehire. And I'm sure you'll see at least one bill that comes up on this, and we can talk more about that. But I just want to be clear that, I don't think the system's position has been that we have no concern. It's more that it's something that we have to watch and watch for trends in retire, rehire to make sure that we don't have to bring a concern forward to you.
Thank you.
Representative Cuddy.
Thank you. And Ms. Moran, that was me earlier that said that. And you would think after a couple of years, I would know better than to speak for anybody but myself. So I apologize for having done that. And thank you very much for clearing that up.
You're welcome.
Any other questions? Well, thank you very much. Thanks for being here, and we appreciate all your contribution. So
You're
have
welcome.
a good afternoon.
Thank you. You too.
Alyssa, are you seeing anything else out there?
She was the last person registered.
Okay. Well, I think that we've received all the testimony for today that we're going to hear. So I'll close the public hearing on LD 111. And I don't see any other hands up or anything. Anything else, folks, before we go? All right, well, I'll, Representative Sylvester, you told me I should have a gavel. I just found a piece of plywood in my cellar. I mean, a piece of 2x4 in my cellar, so I'm gonna use that.
That works.
All right. Well, we are officially adjourned. Have a good day.